I went down for the conference committee and you guys had already wrapped up. Talked to Matt, said you did exactly what was on that piece of paper.
Yes,
Oh, that's no worries. No worries at all.
You didn't come, so I turned it in and off we went.
No, that's fine. How we doing on getting live? Okay, well, let's go ahead and call the meeting to order. A little bit of housekeeping before we tackle into bills today, and we do have a big lift. But we have two items. On Friday at noon, we'll meet with our friends down in the house to talk about interim topics. So you might peruse those and have some thoughts in mind. And then I'll try to get that scheduled for like 20 minutes after we adjourn so you can grab some lunch and then go to the meeting. Secondly, we have confirmation hearing for Chris Petrie. It's a reappointment. We don't have to do it, but I actually think it's a very respectful thing to do. And we could talk about PSC policy and going forward. And a couple of you guys are new to kind of working on interim with the PSC. So I'd like to do that, but maybe at a very reasonable time on Friday morning. And it won't take very long. It'll be less than an hour. So we could start at 9 or something like that. That's my thinking. Okay, well, let's pick up where we left off on 176 in gross vacancies in public office amendments. It's a House bill. And we were taking public testimony. Was there any public testimony online on this bill? Okay, any more public testimony in the room here? Any more? So Representative Bratton, did you want to address us again? Do you want to come up and use the microphone, please? Go ahead.
Thank you, Mr. Chair. Thank you, Mr. Chairman. I do have a letter from one of my county commissioners, and there's a copy. I believe everybody has a copy of that. They were just given. I could read it, or you could just read it from her.
I'm not seeing it, but go.
Sorry,
It's coming.
it was given to you, but here's another.
She did email, but it was late last night, so. I know I haven't checked my emails yet.
Go ahead. Let us take a look at it. Holly Jennings,
Yes, Commissioner.
Sheridan County Commissioner. Yeah. Do we have a copy for Senator Bonner? We passed him by. There's a letter relevant to House Bill 176 engrossed. We went online. No one is here to testify online, and no one's in the audience, but we do have this letter.
Mr. Chairman, there is one person online, I believe, sorry, they didn't put down which bill, but they raised their hand.
All right. We'll get to them next. Okay. Did you want to comment on this letter, Representative Bratton?
I don't think so. Well, yes, I would like to comment if that'd
Okay.
be all right, Mr. Chairman. So I just appreciated the commissioner writing this letter in support of this bill. She obviously could speak to the thing that happened in our county, and ultimately she was selected, and I think she said that she received more votes than anybody ever received in our county, even after she was denied being selected as a county commissioner, and actually the second of the three persons who were selected by the party and sent to the commissioners, which they also didn't select, was also elected in the next general election. So,
All right, thank you for that. Let's take the online testimony and then we'll work the bill. The person that has their hand raised.
Elena Campbell.
Okay, let's let her in.
Mr. Chairman, Elena Campbell from Sheridan County. I appreciate you hearing all of us today. This bill in front of you right now, very much in support of, but also please don't allow yourself to get filibustered. You have a lot of good bills in front of your committee today. Very sensible, been vetted well on the House side. You guys are running short on time, and I'd love to see some of these election integrity bills just move on through. Thank you so much.
Thank you for telling us that. Appreciate it. Any questions for Ms. Campbell? All right. Anything else online?
No, Mr.
Anything else in the room? Committee, you've heard the testimony. What is your pleasure? What is your pleasure? Got a motion? Discussion, Senator Landon?
Mr. Chairman, I've spent quite a bit of time thinking about this bill, and Representative, appreciate all your effort and time. And yesterday you brought a kind of a rewrite of the bill, but the fact is, committee, it made its way all the way to the Senate Corporations Committee, and the intention of the bill, we discovered a couple of days ago, was to centralize at the state level the selection of folks who would be filling a vacancy. And I just have a great deal of heartburn with that. I just honestly, taking away from the county's ability to select 3 people is a real deal breaker for me. A huge policy concern and consideration. Mr. Chairman, so last night I was thinking we already have a request for an interim topic from our Secretary of State on any of these bills that don't make it through the process. So that'll be in front of us for the interim. For all those reasons, I honestly, committee, don't believe this bill is ready. I think to work it for another hour, maybe we could get it into shape where some of us could support it. But for me, I'm going to move to table this bill.
Okay. Motion is on the table to table the bill. Let's have a roll call.
Mr. Chairman, for the discussion.
Not on a motion to table. That's the one motion that there's no discussion. Go ahead.
This is a roll call vote on a motion to table House Bill 176, vacancies in public office amendments. Senator Boner?
No.
Senator Dockstetter?
Aye.
Senator Landon?
Aye.
Senator Steinmetz?
No.
Chairman Case?
Aye.
You have 3 ayes and 2 noes, and the motion to table passes.
Thank you very much. Thank you, Representative. The next bill for our consideration is House Bill 190, engrossed bond election language process. And we have a patient representative. It's been here like every day for the past 5 days. Welcome.
Thank you, Mr. Chairman. My name is Jamie Lean, House District 38, and before you today is House Bill 190. I did just hand your clerk a handout so that you can follow along with the bond language from the County ballot in 2024. I'm just going to read Proposition 1 to you. $7,300,000 and interest earned thereon to the city of Casper to reconstruct the aging, failing, and undersized Metro Animal Shelter to better provide for animal health and safety. There's 8 propositions altogether. Only 2 of them are true and impartial. After reviewing the bond language, I thought it important to bring it to this legislature that we put in the words on page 2, line 6, in a true and impartial manner for bonding language. This does not impair the municipalities or counties' ability to use this to use the bond in any way. It's not changing the value in which they're distributed or the ability to put it on the ballot. This just makes it so there's no heartstrings tied to a ballot measure for the bond. The one change that we did make in the House was that I had submitted that we give the oversight to the Secretary of State because he oversees all of our election matters. We gave the power back to the clerks, but we did put in there a civil cause of action for the individual if they feel that any language is not true and impartial, that they could challenge it, and that the courts then could not collect the bond, or the county or municipality could not collect the bond until the action had been resolved within a lawsuit. The reason for that is because if the county or municipality collected the bond, there would be no way to return those funds back to the individual that had spent the money for the bond. So with you today, I ask for us to snip some heartstrings on the bonding language, and I'll stand for any questions.
Thank you, Representative. Questions for Representative Lean? Definitely like the gross bill better. It's a nice bill. Keep going, Senator Landon.
Thank you, Mr.
You're not
Chairman.
going to table this one, are you?
No. So, good morning, Representative. So my question is, have you considered or thought about how the process would be to write the language? Is that something that the clerk then would draft the language and make it available to the public so that we know if it's impartial? Or talk to me a little bit about, prior to putting language on the ballot, how can the clerk assure that it's not going to be considered impartial?
Representative Lean.
Mr. Chairman, Representative Landon, the current process that happened with this current ballot in front of you is that the city council wrote the language, they submitted it to the clerk. The clerk reviewed it. If they had any questions, they were to go back to city council to make sure that the punctuation was correct, the verbiage was correct, and then they are the ones, the clerk is the ones that put it on the ballot. This also was available prior to the election for people to see, and it does come out on the sample ballot, so those that believe that it might be not true and impartial could have the opportunity to challenge it before it's voted on.
Go ahead.
So just as a
I
follow-up.
can see that head cocking a little.
Yeah. So just as a follow-up, would we have had an opportunity, those of us in Natrona County, would we have been able to change the language now? I mean, if we'd have gone to the clerk, I wonder if we would have been able to change it now.
Representative Lean.
Mr. Chairman, the Casper City Council did hold a public meeting while they were drafting the language, and those that were interested were able to be a part of that process to hear it. And I do believe that if an individual had concerns, they could contact the municipality or county that is writing the bond language ahead of time. And then they could be a part of that process because it is open to the public, as well as then when the clerk has it for draft, and then in the provisional process, there would be an oversight from the public to have the opportunity to clear it up before it becomes a permanent placement on the ballot.
Anybody else? Anybody else? Questions for Representative Lean? What is the civil cause of action? How do you envision that playing out? Go ahead.
Mr. Chairman, thank you for the question. I anticipate it to be that if it is challenged in court because there was no resolve on the county level, that the judge would have the ultimate authority to decide if it was a true and impartial matter, that the bond would be placed on hold. And then if it is found to be true and impartial, they could then go ahead and collect it. If it passed on the ballot, if it did not pass, or if it did pass on the ballot, but it was found to not be true and impartial, that it had adjectives in it, that they would then not be able to collect it.
Okay, so that would be the limit of that's the way the judge, that'd be his powers. They would, so they could discontinue the bond election in essence.
Mr. Chairman, yes, that is correct.
Okay. Anybody else? Let's hear if we've got other testimony on this. Thank you very much. Appreciate your patience. I know you ran close by. Who else would like to testify on this bill? Anybody in the audience? Ms. Simmons? Let's fill it. And Secretary of State, you want to come first? Yeah, we'll fill out the chairs. And did you hear that person talk earlier? She was very wise about how many people could filibuster bills today. Secretary of State.
Well, thank you, Mr. Chairman. I'm Chuck Gray, the Wyoming Secretary of State. To my right is Joe Rubino, our Policy Director and General Counsel. I stand in support of HB 190. This bill would require bond questions to be written in a true and improper manner, impartial, manner. The use of adjectives is not proper in a ballot, and mandating true and impartial language is an appropriate safeguard. I think Representative Lean just handed out what we saw in Natrona County here, my home county, in this last election, and it was very disturbing to me. I mean, Proposition 7, $3.6 million in interest earned thereon to the city of Casper to build a new auxiliary gym to provide much needed space for programming, ... Or $4.2 million in interest earned thereon to the city of Casper to install a new quad capacity chairlift to replace the aging and outdated ... I mean, it just was not, it was not proper, in my opinion. And that's what the problem we're trying to address. For statewide issues, it says that the Secretary of State is to make sure they are impartial. And so we just need to get in alignment with that, with these local matters. Over the last decade, the legislature's really written in a lot of authority for the localities to do these things, especially in the last 5 years. This is really cleanup, I think, to make sure that we get this true and impartial language in there and align it with the statewide issues. So I'm very in support of the bill. Thank you.
Thank you, Mr. Secretary. Questions, sir? Senator Doc Stater.
Thank you, Mr. Secretary. This originates out of your home county, originates out of Natrona. These are good examples, but do you have any other examples from any of the other 22 counties?
Mr. Secretary.
Mr. Chairman, I do not. I think that I'm not saying that hasn't happened, though. I mean, we've wanted to review the ballots from all 23 counties, but unfortunately, that hasn't. We've asked the counties to allow us to do that before they proof them, and that has not always happened, and the statute doesn't require it. I think it's something just to look in the interim. I think it's great to get another set of eyes on it. So I'd love to have another set of eyes on these ballots before they go out for printing. This was sent to me actually by a concerned citizen. And so I don't have any others, but I think there's reasons to believe that there may very well be others. I want to be very clear on that.
Okay.
Thank you.
Anybody else? Senator Landon.
So real quickly, Secretary, I'm with you on this one. I'm trying to figure out whose eyes and how are we going to police this up front? And maybe we speak to the clerks about that too. I don't know who decides the impartiality of a ballot measure. That's what I'm trying to get my arms around. I like the concept of the bill. I'm just trying to figure out, well, how, I'm looking at my journalism friend down here. I'm not sure how we make sure that something's objective and impartial, and who does that?
Ms. Secretary.
Well, Mr. Chairman, thanks for bringing up journalism. I was actually going to add that to my comments, but then I didn't want to take from time. But, I went to journalism school, or a sort of high school program, decide if you wanted to go. And this was in 2008, or 2006. You weren't supposed to use any adjectives or adverbs. And every time you used one, your grade would lower one level in an article. Now, of course, that's changed so much in the last decade and a half in our country, but it's the same principle here. In terms of who reviews them, I think the state, through our office, I'm going to make a pitch for that. That was the original drafting of the bill. I'm sure the clerks might be interested in it as well. I think it's very good for the state to be involved in that. I think not that it would affect their judgment any, but I think there could be a perception of a conflict since these things interact with the counties and the localities that they're in. So I think I really believe the chief election official of the state of Wyoming should be reviewing these. I think it would help in starting to get our eyes on some of these ballot proofs as well. It would have that effect as well. So that's my view on that question. Thank you for it. Thank you.
Anybody else? Mr. Secretary, I was just looking at the engrossed bill, both bills actually. The old language has this language that the Secretary of State may promulgate reasonable rules for conducting bond elections where the election is not held at the same time as the general or primary election. Can you illuminate for me what that is? I mean, I understand that you can have bond elections on special election days. And I think there's actually set-aside days in the law. But what's the nature of the rules that are involved in that? And this is, of course, everybody, this is current language, it's existing language. Yeah, Mr. Secretary.
Well, Mr. Chairman, I think they put that in to help in administering an election outside of the regular period when they open this up, in whether it was 2019, 2020, 21, or 22, I don't really recall. It's one of those years, and I think it was actually 2 iterations of that. I don't know if you remember, is my recollection. And I think they put that in there to really help us in trying to administer off elections that were going to become more frequent with the change in the statute. And they did become more frequent. I think we saw with Representative Stivar's bill, some of the trying to clean up that issue as well. So I think that's what they were getting at there.
Okay. Thank you very much. Anybody else? Thank you. Ms. Simmons.
Gail Simmons, Civics 307 and Y vote. I'm not for or against. I'm just concerned about the lack of specificity in the bill, Mr. Chairman, and specifically, first on true and impartial manner. Until somebody mentioned adjectives, I couldn't figure out what would be the basis for determining if something is true and impartial. So the example given, Mr. Chairman, of aging and outdated sounds like it could be true and accurate. So I'm not sure that would meet the criteria. If there was something in here that gave a little bit more guidelines as to what specifically is identified as true and impartial, that might be more helpful, and it would certainly make it easier to comply with. The second one is on all of the civil cause of action, because, again, of the lack of specifics on true and impartial, this basically opens the door for one individual to completely control any bond election by determining that they don't like the language. So if there was a time frame in which somebody could put something in, or some criteria so that one individual who doesn't like the bond issue cannot halt the whole thing, then that would make it better. So I agree with the need for good language, but this bill basically, like I said, my biggest concern is one person who doesn't like this can bring a civil action and blow the whole thing up, particularly since it's not specific on what is meant by true and impartial. And that's.
Okay, questions for Ms. Simmons? Questions? Senator Steinmetz.
Thank you, Mr. Chairman, and I appreciate that concern. However, do you see that possibly one person could weight the language of this as well, whoever's writing it?
Mr. Chairman?
Ms. Simmons.
Senator Steinmetz, if there was only one person who is writing this, I believe that would be accurate. And in the description of how that particular bond issue, the one that is currently initiated this, what I heard was that a group of people came together on how they were going to do this. They had public hearings, and they actually took input from the public on what that language would be. So while I think that would be a concern if only one person was writing this, but I think that the processes that are in place before finalizing the language would prevent that.
Anybody else? Ms. Simmons, I do get your point about one person holding up the bond election. It could be extremely frivolous because the last sentence and it's new language in the gross bill, a bond challenged under this section shall not be issued until after a civil action is complete. You guys, that's pretty open-ended as what that might mean. And it could be, there could be some stacking going on if other people were to, if it was disposed of, then someone else filed another one. Is that kind of where you're going out with the concerns? And would you think of a fix in that area, Ms. Simmons?
Mr. Chairman, yes. In fact, I think that rather than a civil, we're pretty litigious. And I'm always kind of amused by the idea of lawfare and the way in which people claim that that's happening and then do things themselves. I would remove that entire additional section and simply require rules for evaluation. And again, maybe that can come through the Secretary of State's office, but promulgate rules on the criteria for meeting true and impartial manner. And maybe even a process to evaluate. So I think the answer is in tightening up the writing and not adding in a civil cause of action.
Okay, thank you. Anybody else? Thank you very much. Who else would like to testify on this bill? Who else? Anybody else in the audience? I'm not seeing anybody in the audience. Is there anybody online? Representative Lean, would you mind rejoining us? Talk to you about a couple of things. How essential is that last sentence to the bill?
Mr. Chairman, my opinion about that last sentence is that it's compelling the clerks to make sure that the language is true and impartial, that without it, that there's no penalty.
Could you speculate on what would happen if we took that sentence out? It would still allow the courts to act, but it doesn't provide specific direction to the courts.
My concern would be that if we collected the bond and then it was found to be that it was not true and impartial, that the taxpayers that have been paying the bond have no recourse at that point. That the bond has still been collected and then nobody's able to get their money back, because when you add that bond to your sales tax, it would be impossible to return it penny for penny to all of the individuals.
Just following up, and I see there's other questions. I'm not sure a judge would be precluded from injuncting the bond.
Okay.
But I think it makes it more, just thinking out loud, it might be good to have a judge have discretion about injuncting the bond, rather than saying, that, in essence, the bond is put on hold just because someone filed an action. You see what I'm trying to say? And help me, members of the committee. Senator Boner.
Thank you, Mr. Chairman. Maybe we can just strike the shall and insert a may. So it's up to the judge, or that would be my suggestion.
Yeah, that might work.
Line 16.
Do you see what we're talking about, Representative?
Mr. Chairman, I do. And Mr. Senator Boner, I do appreciate that suggestion, and I would be open to whatever the committee's will is.
Okay, Senator Landon.
So, Mr. Chairman, thank you. And so, Representative, I'm trying to think of what we could do on the front end to avoid having on the backside. Does that make sense? And I'm wondering if you had any conversations on the other side about what sort of process. I'm intrigued by Ms. Simmons suggesting that maybe we provide for rules through the Secretary of State that bond language is to be read and approved or evaluated in some manner and must be in place a month before it's to hit the ballot box. Or does that make sense? It seems like there ought to be a way up front that we can avoid this in the first place.
Representative Lean.
Mr. Chairman and Senator Landon, thank you. In the original copy, we gave 130 days before the bond election, submitting the bond question and the county clerk under this section. The political subdivision shall submit the proposed bond question to the Secretary of State for approval. Not less than 120 days before the bond election, the Secretary of State shall approve the form and the bond question if it complies with this section, modifying the language to form to continue with this section if necessary, and notify the political subdivision of the approval or modifications for the bond question. And I'm open to reinserting that if you feel that that gives it more oversight and a better time frame for the clerks.
Senator, go ahead.
So
Thank you, Representative.
if we were to, Representative, we move all or any portion of that back into the bill, Any concerns on what that would do to the bill in your chamber?
Representative?
Chairman, Senator Landon, no, this passed overwhelmingly out of the chamber, and I do believe that if that was to come back in, it would also.
Okay, thank you.
Senator Steinmetz?
Thank you, Mr. Chairman. Could you just tell us why it was taken out?
Yeah.
Mr. Chairman, Senator Steinmetz, there was a belief that this took away the local control, but if you read it, the county clerk still has the ultimate authority, and they're the ones that submit it to the Secretary of State for oversight. So it's my opinion that the county clerk has the ultimate authority because they review it prior to sending it to the Secretary of State's office.
Can I venture in here a little bit, you guys? And I wonder if we could go into the part where the Secretary of State makes rules and modify that to have him also make rules about the ballot language. And then at the end of the bill, we could take up Senator Boner's suggestion to make it permissive for the court. And I don't know if that would get in us trouble with the bill title. I don't think so. That language right now on, and Representative Lean, work with me on this a little bit. Page 2 of the engrossed bill, that sentence that starts with the Secretary of State in the middle of it says the Secretary of State may promulgate reasonable rules for conducting bond elections where the election is not held at the same time as general or primary election. I kind of get that, but I'm hoping that we might expand the rulemaking there. And I'll throw out to you, the Secretary of State may promulgate reasonable rules for conducting bond elections and ballot language, period. And delete the rest of the sentence. Then we keep the sentence that says a qualified elector may bring a civil cause. And then the last sentence we make permissive with respect to the court. Do you think that would work, possibly?
Mr.
To you,
Chairman?
yeah.
Yes, I do believe that that would work. And the existing language about the Secretary of State, I did not change. And so
Right.
I'm open to modifying the statute as necessary to make sure that this is the best policy possible for the election integrity.
In committee, I think only one issue might be, someone could say, well, you're giving the Secretary of State more power with respect to bond elections that are held at concurrent with an election. But I'm not sure I see that concern. And it sort of would expand his area there, as well as give him the ability to promulgate rules about the language, being true and impartial according to law, and what that means. And then we allow the court permissive. Up to you, Senator Landon.
Well, Mr. Chairman, I like where we're going, and as the Secretary knows, being a journalism student, every writer needs an editor. And so, I don't see any problems with moving in a direction to get more eyes on some language. I don't want it to hold anything up, and obviously there's a lot of work to be done in the clerk's offices, et cetera, but I don't see that as hanging it up for that long. Any concerns, Representative, I kind of like where the chairman's going.
Representative?
Chairman, Senator Landon, I'm not concerned by any of the conversation here today, and I welcome whatever you see fit to help me make this the best bill possible.
Thank you. And Senator Dockstader.
Mr. Chairman, as a safety net and for the sake of the sponsor, could you repeat what you're proposing to do there?
Okay, but I'll need somebody else to make the motion, but I would propose on line 9, that sentence starts with the Secretary of State. We would rewrite that sentence so it says the Secretary of State may promulgate reasonable rules for conducting bond elections and ballot language of bond elections, period. And then at the end, I don't mean to steal Senator Boner's thunder, but a bond challenged under this section may we might say the court may stay a bond challenged under this section pending resolution of the civil action. And be very clear, it's a may. Does that get at you, Senator Boner? You had better language, I think.
Well, I just keep it simple and strike shall and insert may.
Yeah. That's probably easier.
Mr. Chairman, I'd be with keeping it simple, inserting may.
Okay?
But could we, Mr. Chairman, also have some response back from the sponsor on that change on line 9?
Go ahead.
Thank you, Mr. Chairman. Senator Dockstetter, that change would be very acceptable.
Okay. Does anybody, well, let's see if we got more public testimony. Thank you, Representative. I don't recall any, here comes the clerks. Please come forward. Ms. Langford.
Good morning, Mr. Chairman and committee. I'm Mary Langford, and I have the honor of representing the county clerks of Wyoming. I can't speak for the Natrona County Clerk and what happened in Natrona County with this particular election. And in my experience with bond elections, and usually this is like a special purpose election question that came here. Those questions come from various places. There are public hearings that are held to develop that language. The language comes from attorneys. The county attorney reviews and looks at that language. And the one thing that I did want you to know is that there is public notice of those questions to the public when they make the proclamation for the election. So there is time to look at those and to comment and that type of thing in the law right now. Just, for your information with that. So as far as more review away, concerns me that one place would be reviewing 23 counties worth of special district or special purpose elections, whether that work gets put out as fast as it can be. Times are short to get ballots made and that type of thing to
So
keep.
I don't think the committee's coming down on having it go to the Secretary of State. I haven't heard that. And that was a change from the House version.
Yeah.
But I think we are coming down on having the Secretary of State promulgate rules about the content of the language.
Well, and Mr. Chairman, one other thing maybe to consider also is that maybe there's some standardized language on how those questions come out, that it's this, it's this many $1 million with this interest for this project, period, without any description or any heartstrings or any of that type of thing to go with it, where that's the way, if you're looking at sales tax questions, those are statutory questions that says this is how much and what the percentage is and that type of thing. And then there would be uniformity across the state that people would be able to rely on for these kinds of questions and take the emotion out of it.
Thank you. Senator Landon, did you have your hand up?
Well, just real quickly, Mr. Chairman, Ms. Langford, what kind of time frame do you need in front of a bond election, for example? I guess we're gonna suggest that it go to rule a little bit.
Yeah.
But if it does that, what kind of time frame do you need to get?
Well, the only-
Ms. Langford?
Mr. Chairman and Senator Landon, the thing that would concern, I think would be the concern is that if there was something that came out on if a question came and during that review time that is allowed there, what I think it's 101 days or whatever.
That's the
there's-
old bill.
Yeah,
We're talking about the engrossed bill.
the engrossed bill. But there would be, as long as there's time enough there, if you consider there's 23 counties that has a list of 10 questions, that's a lot of review for one place to be taken, and that's out, I understand also.
But
At
let's
this
get,
point.
the engrossed bill doesn't have all that. It's essentially the same review now. It just says it needs to be in a true and impartial manner, and it allows a qualified elector to bring an action. So it doesn't change any time phrase, doesn't redirect it to different places at all. Let's stick to the engrossed bill.
Mr. Chairman, that's my fault for the question, and it's irrelevant, but they can deal with that in rules, so.
Okay.
Thank you, I'm sorry.
Mr. Chairman,
ahead.
Senator Landon, I agree with that. I think rules would be good here.
Yeah.
Yeah.
Okay. Anything else?
Thank you.
Anybody else? Thank you.
Thank you.
Anybody else in the audience wish to address this bill? Anybody else in the audience? Not seeing anybody. Anybody online wish to address? Did you say no?
No.
Okay. Committee, you've heard testimony. What is your pleasure on House Bill 190 engrossed? Got a motion by Dockstader. Any proposed amendments?
Chairman,
Go ahead.
on line 10.
Yes.
Thank you,
Let's
Senator
get, we're going to
Bonner.
get the microphone going and
Line
start
10,
over again.
I'm going to try my best to reiterate where you were headed with the language beginning on line 9. The Secretary of State may promulgate reasonable rules for conducting bond elections and bond language,
Bond election language?
bond election language to be
Period.
inserted, period.
And then we'd be striking the rest of the,
That's correct.
okay? Were you going to, at the same time, deal with the last sentence, or we'll let Senator Bonner do that?
I think Senator Bonner is on that one.
Okay, let's, discussion. All those in favor signify by saying aye.
Aye.
It looks like that's carried. Senator Bonner,
Thank you, Mr. Chairman. Page 2, line 16, strike shall, insert may.
thank you. Any discussion? All those in favor signify by saying aye.
Mr. Chairman,
Yep.
just to clarify, do you mean, Senator Boner, right, if you put may, it says a bond challenged under this section may not be issued until after a civil action is complete? Do you
Yeah, it
mean-
kinda means
Did you
so.
mean that a bond challenge under this section may be stayed?
Yeah. Remember, it is a little bit more complicated. Maybe using that fine legal mind that we have over there. Would it be better to say the court may stay a bond challenge under this section?
Yes.
Okay. Everybody good with that? A court may challenge,
May
a
stay.
court may stay a bond challenge under this section. And it's clear that that is permissive, whereas the other one wasn't clear. Yeah. Okay,
May I just have a little bit, when I do the amendment, could I have
A
a
little
little
fudge?
bit of,
we're giving her a little fudge, you guys.
Okay,
Keep an eye on her.
No conceptual deal there.
Okay. Discussion, all those in favor signify by saying aye.
Aye.
Okay, anything else on the bill? Anything else? Let's call the roll on the bill.
this is a roll call vote on House Bill 190, engrossed bond election language process. Senator Boner.
Aye.
Senator Dockstetter.
Aye.
I'm sorry, I didn't hear that. Senator Landon.
Aye.
Senator Steinmetz. Chairman Case.
Aye,
You have 5 ayes.
great. And we have, do we have a Senate sponsor on that? I just put it away. Who's on that for the Senate? No one. Does anybody want to volunteer from this committee?
I can do it.
Senator Boner, you can work with Representative Lean. Thank you very much, Representative. Good job and appreciate it. All right, the next bill for our consideration is House Bill number 249, engrossed runoff elections, and Representative Nyman is here. Welcome, sir. Didn't have to wait so long this time.
You guys have been so patient with me. I really appreciate it, Mr. Chairman.
Good to see you.
Good morning,
Go ahead.
ladies and gentlemen. Mr. Chairman, members of the committee, I bring you House Bills 249, runoff elections, and would ask for your favorable consideration. Just to give you a little bit of background, I've been personally working on this piece of legislation and with the good people of the Clerks Association and the Secretary of State for the past basically 4 years in an effort to try to see if we can come to some kind of a way of maybe changing this. And no, bear in mind, and you all fully understand this is a policy decision that is an extremely large policy decision for the state of Wyoming. But I believe it is necessary from this standpoint. Because of the way that Wyoming is made up, our elections really, because of our supermajority Republican state as one-party state right now, in my mind, our elections actually take place in our primary. Because if you win the primary in Wyoming in a Republican primary, no matter what percentage that is, we elect with a plurality. We don't elect with the majority in our primaries. So whatever you leave with, you're going to go on to the next general election, and you are probably, can't say always, but you're probably going to be the nominee or the elector in that particular general election. So that is why I'm very, very interested in this and very, very committed to trying to do something about making sure that if somebody's going to go forward out of that primary, that they have at least a majority plus one vote of the electorate in order to be able to be going forward. I give you a couple examples, and there are some other folks behind me that I'm sure that can give even further examples. In the last election, and I'm not trying to give anybody a hard time, but just giving you actual figures. Our current governor was elected out of his primary with 34% of the vote come out of it. Prior to that, we had another governor that was elected with 28% of the vote. And so it concerns me in the fact that 60-some% of the rest of the state, and potentially over 70% of the state, would prefer to have had another option or was looking for somebody else to represent them. So in these situations, and I've changed this piece of legislation. Initially, I had representatives and senators in this, but it's just not working. My focus has then changed to come on to the idea that we want to make sure that the folks that are in these top 5 elected positions, statewide elected positions or national positions, should have at least 50% of the state's membership that have elected or voted in those elections support in order to go on and become elected. And I guess that's really what it boils down to. It's really as weighty and as heavy as this chunk of bill is, and legislation, many trees that died for this. It's really pretty simple. Do we as a state want to make sure that the person that moves out of the primary has at least 50% of the vote? And if not, then that's the reasoning behind the need for a runoff. If the top 2 electors would be picked from that, and then they would have the opportunity to be able to go and garner the support of the rest of the state of Wyoming in runoff election. And then that person would then have at least 50% plus 1 of that vote to move on to the general. And so what we're going to see as you look through the bill, the biggest part of this, and that's why I do appreciate the work of you folks, and I really appreciate the work of the Clerks Association. I've worked very diligently with those folks in an effort to make sure that we can do this. And I have been assured, and I trust that they will come behind me and also share the fact that this can be done, that the timelines are there. I believe we've put a lot of work in with those folks in an effort to try to make sure that we can accomplish this and not make it too onerous. The issue that we're going to deal with, and it's a policy issue, is this will move our elections up in the course of the year, because we have to allow enough time between each election to allow everyone to be able to vote and be able to get absentee ballots to folks that are distant areas from here and make sure that they can be a part of the election. Another part of this that we've crafted in here is that you don't have to have voted in the primary in order to be able to vote in the runoff. As long as you're a qualified elector, you may vote, if you haven't voted in the primary, to vote in the runoff. And so in an effort to try to make sure that we don't disenfranchise and we don't limit people's ability to be able to opine on this and make those decisions in leading the state, we've allowed for compensation for any potential costs to the counties. There is an appropriation in this bill, ladies and gentlemen, and that is going to be based on what it would take, and that will set with our Secretary of State. And in the case that any of the counties would have costs incurred, that they would be reimbursed for actual costs. And so that is something else that was a part of this that we're so concerned is going to be additional cost. Ladies and gentlemen, I would submit the idea that I think it is worth it. And I've talked to many people in the course of the last 40 years that it is worth it to make sure that we have that kind of majority vote of those folks that are going forward to represent us in that position. There's folks that are going to be coming behind me here. I mean, I would be glad to try to answer any questions. Basically, this entire piece of legislation goes through all of our statutes that would be tasked with changes to and add the word runoff. Some of our language here that has been changing some of our times. That is very much, and I'm not going to sit here and try to snow you that I'm going to list you all, explain how, why, all that. I'm going to leave that to the good folks that would be required to implement this, and they have a very good understanding of it, and we've worked very diligently to make sure that that is implementable, and I would hope that they would be able to answer any of your questions in regards to that. My position in this, ladies and gentlemen, is I believe that we need to have the ability to make sure that the folks that are representing us, especially in our top elected positions, have at least 50% of the vote to move forward. And that is the reason behind this bill, sir. And I would be glad to try to answer any questions if you have some, Chairman.
Thank you, Representative. Any questions for Representative Nyman? Any questions, Senator Landon?
Thank you, Representative. Appreciate it. So we pondered this for a while, as you know, and I've always wondered if there was any concern over this being a cost driver. Having to literally run a third tier of an election campaign, for example. It just seems like, these races are becoming more and more expensive for the good old average Wyoming Joe or Jill to jump in a race. Any concerns on that front?
Representative
Mr.
Nyman.
Chairman, through you to Senator Landon, I'm sure this would be potentially a problem for, more costs. You're running an additional election and that you can, I don't know. If you've run and you've won your race, you continue to move on to the general. Quite frankly, in these situations, the folks that we're talking about here that are going to be affected, quite frankly, Senator, are already running. We've already got people that have announced for these positions and are actively moving on trying to be elected. So they're spending some serious dollars already early in the race. The thing that I think the additional cost could be, if you're going to have to run off against someone else, you are probably going to want to spend some dollars to try to capture and to encourage those folks that did not vote for you previously or may have voted for other candidates that now are no longer on the ballot. You're going to be tasked and challenged with trying to get them to understand why you are the best selection for them and court their vote. That's probably going to cost money. There's no question about that. And yes, sir, elections are getting more expensive. In my first election just 2 cycles ago, I spent around $18,000 to get elected. And that would be, in some races, as of this last election, that would hardly make the skillet stink, so to speak. So yes, we're seeing a vast increase in the dollars that are being invested in elections, and I won't pull your legs here. Potentially it could, but I think I still go back to the idea that I would like to have somebody put a lot of effort and support from other people to push that election to a point where we've got an elector that is going to be getting at least a majority of that vote. And I think we owe that to the people of Wyoming, because, and as I think about this, sir, Mr. Chairman, let's say you've got 8 people in a race. And quite frankly, I did a little just doodling on this, and we got about 7 or 8 that are smelling around running for governor this go around. They all have the resources. And
Some of them are in this room.
I'll let you guys sort that out. If you got the dollars to stay in this and you all hang in there, you could win with 15% of the vote. You could be the next governor of the state of Wyoming under our current system with about 15% of the vote. And I don't know about you, ladies and gentlemen, that concerns me. And I think we need to put more effort into it than that. And I think it's the only reason this is important, ladies and gentlemen, is because of the fact that we are a supermajority state. Our primary, like I said initially, I would actually ask if anybody knows of very many examples where the primary didn't already determine who won the general. And so with that large of a field, that small of a necessity to be able to forward that candidate, personally, I think we do the state a disservice, and I think we need to change how we do this, sir. So.
Okay, anybody else? Senator Dockstader, you made a change your mind. Anybody else? Anybody else? So I'll just venture in here a little bit. Representative, I get your point if we didn't have political parties. Okay, so imagine we didn't have political parties and we had a election, initial election, then a second election to try to find who will be our governor, just make things up.
Sure.
And it does seem that you could certainly have exactly what you say with respect to the math. Someone could get in with a small percentage, and in the end, they wouldn't be representative of the state as a whole. And so that inserting another step to narrow the field down is beneficial. It kind of helps to focus it, and I get that completely, 100%. It's just when we have such partisan, when you add parties on top of that, it changes the nexus a little bit. And what I'm getting at is that sometimes, and we can use this current governor who has, by all accounts, the situation was as you described in his election, and probably would have been different with a runoff election. Quite possibly could have been different, maybe not, I don't know for sure. But right now, at least statistically, and I'm not trying to be argumentative. I just want to say, it seems that he enjoys a high level of approval from the entirety of the state. Not maybe necessarily from the entirety of the Central Committee of the Republican Party, for example. But, so my point is, I guess that adding a runoff to a situation that's really not an open type election kind of further narrows it into being even more partisan. I'm just throwing that out there and look forward to your response. Thank you, sir.
Mr. Chairman, thank you for the question. While it would be great that everybody that got less than half the majority would continue on and would gain more favor, as what I guess we would say, what happens if they don't? What happens if 70-some% of the people of the state of Wyoming said, what in the world did we do? Why didn't we have a second go-round? I mean, this didn't get better. This particular candidate only got 27% or 26% of the vote, and now we know why. And so while I appreciate the fact that our current governor seems to enjoy a very majority popularity and has grown from that, I would hate to see the instances where it doesn't. And so I think this would help to make sure and ensure that. We would also say that in that situation, if there would have been a runoff, maybe the other person that won the runoff would be even more popular or less. We don't know that. And so, but to your point, I get your point, sir. And I understand what you're saying and that, but I still go back to the idea that I would love for my candidate that's going to go on to the general, that they would at least have 50% of the vote plus one.
Thank you very much. Any other questions for the representative? Let's get the, I'm sorry, Senator Steinmetz.
Thank you, Mr. Chairman. Representative, it seems like, how many other states have a runoff statute? Because what we're really talking about is a majority versus a plurality.
Correct.
Go ahead.
Mr. Chairman, do you, Senator Steinmetz? That's what we're talking about. We're talking about a majority versus plurality. Now, the clerks, we can talk about it, and with the Chief Clerk Malcolm, the Director, Chair of the Clerks Association, he was talking about Georgia, and they're looking at some things on what Georgia's doing currently and how their days are working in an effort to do that. So we do have states that are doing runoffs, and so they've been looking at some of their structure and how that would work and how we could implement that in Wyoming. And honestly, on the back of the bill, if you look at it, we did draft the bill with the ability to, because we're not going to do this till 26. And there's also some discussion about redistricting, and the need to, because I brought it before with the constitutional amendment in order to change the Constitution in order to make this work on redistricting years. So we can actually currently, with current state law, have runoff elections for 4 out of the 5 elections right now. Actually, if we look at this and we're looking at how we structure this, we could actually do it, I believe, with the census and not even need a constitutional amendment in a redistricting year. And so, and that's what we're working on, and that's why they wanted to have that section in the back, to have some time to work those days and to work with the Clerks Association and to work with Secretary of State and the Corporations Committee, quite frankly, hopefully you folks as a joint, to be able to assess some of these days, compression of some of the days and make it less drug out in an effort like that. And so there's some language in the back of the bill. I worked with our LSO staff, and they discussed that with the other folks, and they said that would be help to work through those issues and help us to get where we really need to be to make it work. And so that's why that's there. But to answer your question, good Senator, yes, it's a runoff as opposed to a plurality, a majority vote versus a plurality. So, and Georgia is one good example where they're doing it right now and it's working. So.
Okay, committee, and Representative, you're talking about Section 3 of the bill.
Yes, Section 3, sir.
Yeah.
Yes.
All right. Senator Landon.
Just real quickly, Mr. Chairman, thank you. And so Representative, I'm curious about what roadblocks you ran into when you thought about state senator and state representative. You indicated that there was just some concerns there that.
Representative Nyman.
Yeah, Mr. Chairman, Senator Landon, it run into about 93 people that were like, seriously, you want us to do this too, And so, and then upon further consideration, like I said, sir, this has been 4 years trying to work through, seeing what is or isn't acceptable, what will work. I'm at this point where I want to see us have the opportunity to do this on a statewide scale. These are the people that are going to be actually affecting our policy on a statewide and a national level. And that's why I think I've pulled it back in an effort to just approach those folks there that have a statewide effect. And then also, in the same token, those are folks that are going to be running statewide. They're already running. They're running early. Some of the issues were representatives and stuff. In an early discussion with the previous Secretary of State, it was kind of fun in those conversations. He said, they're going to fuss. He said, but I've got representatives that already leave me a check before they leave. So they know they're going to run. When they leave. He said, just cash this when it's time. I'll leave it with you before I leave the Capitol after session. He said, so there's some that are going to do this. He said, but there is a discussion. How many of you want to run again? Right now, I'm 2 weeks out from finishing my third session, and there's days when you could ask me, would you run again next time? Don't ask me that day, because I would not want to run in the middle of it, because it's too hot and right in the middle of it, to have that time to kind of think about it and reevaluate. The top 5 electeds and the nationals, they're a statewide race. They're running. Their minds are already headed in that direction. They know where they're going. And so, quite frankly, if that's something that this body would want to add, if they saw the good in this and how it's working, then I would like to leave that up to this legislature to say, I think that wouldn't be a bad idea. Because I can give you a lot of races around the state where representatives are in a 3-4-way race, and it's a plurality, but I think how do you eat an elephant? One bite at a time. And the greatest journey begins with a single step. So I've tried to be thoughtful about this and not try to run over the top of anybody. I just really believe that we need the opportunity to implement this and to make this work. And ladies and gentlemen, we've got a really good group of clerks. And I've got a good Secretary of State that I think supports this and can see how this can be implemented. And I know my clerks, and working with them for the past 4 years in the association, have assured me that by taking the necessary steps and trying to do this the right way, that they can do this. And so it can be done. And I think there's a will out there to do it. And I think it's a good thing for us to do. Expanding it, that's something we can talk about in a couple of years after we get a couple of these under our belts. That can be added. But let's start here. See how it works, see what the response is from the people of the state of Wyoming because of how our state's made up right now. And I have a lot of folks out there across the state would really appreciate this opportunity. So I really appreciate your time. And so thank you for the opportunity.
Comments, Representative, appreciate it. Yeah,
Okay.
thank you.
Thank you for the questions.
Anybody else? Anybody else? Thank you.
Thank you, Mr. Chairman.
Ms. Secretary, did you want to weigh in on this one? Then we'll go to the clerks and we'll take public comment after that.
Mr. Chairman, I'm Chuck Ray, Wyoming Secretary of State, and talking on House Bill 249, certainly would ask you to move forward the bill. As written, this bill would require a runoff election to be held if a candidate for statewide or federal office in a primary election does not receive 50% of the vote. Now, 9 states do this currently. There are some states that have different thresholds. North Carolina requires a candidate to reach 30%. South Dakota requires a candidate to reach 35% to win their election. But we can implement this bill as written. The bill moves the date of the first primary from August to the first Tuesday after the first Monday in May. The runoff election for statewide and federal offices would be held on the first Tuesday after the second Monday in August. There's a lot of dates moving around in this, but it has been worked on for quite some time. The bill would also require us to provide an additional notice to the county clerks in the event of a runoff. That's in page 24, and would also require candidates in a runoff to file an additional campaign finance disclosure, which is spread across pages 32 through 34. But certainly agree with the intent of this bill of trying to get the will of a larger element of the electorate, but there's a big change. I mean, it's going to cost more money to run these races, and you're going to have candidate filing here in March. So it's a big change. The question's always worth the juice is worth the squeeze. Certainly, I kind of follow that it is, but I also do have do acknowledge that there's some side effects here that are going to change the way things are done.
Thank you, Mr. Secretary. Questions for Secretary Graves? Go ahead, Senator Steinmetz.
Thank you, Mr. Chairman. Mr. Secretary, would it be possible to get a chart, like a graph of, the timeline of what we're looking at, then what current law is, and then the changes and how that would look in a linear basis?
Mr. Secretary.
Thank you, Mr. Chairman and Senator Steinmetz. I can certainly work on that. Yes, certainly do that.
Okay. Anybody else? Any other questions?
Thank you.
Thank you, Mr. Secretary. Would the clerks like to talk about this? Maybe it doesn't affect your office. I don't know. I'm not sure. Ms. Langford, how are you? Go ahead.
Mr. Chairman and committee, I'm Mary Langford, and I get to represent the county clerks of the state of Wyoming. Mr. Chairman, I'd like to also ask, Malcolm Irvin, who is our president, is online
Let's
this
try to bring
morning.
him in.
And could we bring him in so we can tag team a little bit? He's
You
worked
bet.
pretty extensively on this bill. And as the speaker said, this is how much we've worked on this bill over the last 4 years. This started 4 years ago with the Secretary of State's office and a group of county clerks. I was able to participate in that as well. And we, of course, realize there's a big policy decision that needs to be made here, but we also have been really concerned about the administrative piece of that, because that's what the clerks are going to be responsible for, the timelines for all of the notices and filing and all that type of thing. We've been tracking those really closely. At this point, I believe we're at the point, right now, we're good. We're able to administer the way this is. We also are concerned about the funding. We appreciate the fiscal note that's in there. Do you realize that if we do an extra election in May, that is right in the middle of county budget time, and county clerks are also the chief budget officer in their county, so it's a really busy time of year. Could require us to add some additional staffing and those types of things. But with that, I'd like to hand off to President Irvin and let him continue the discussion here, and I'm happy to answer any questions as well.
I think that's fair. I see he's on. Well, welcome, President.
Thank you, Mr. Chairman. I really apologize I can't be there in person, but I appreciate the opportunity to participate remotely. Worked really hard with Representative Nyman on this bill for the last 4 years to get it to a point where we could say we could administer it, and that is the case with this bill as written. I do have a couple of amendments I'd like the committee to consider. Second reading in the House, there was a bit of a shift. The bill as introduced had everybody's primary in May. A second reading amendment altered it to where the federal and top 5 elected officials primary was in May. The legislative, county, municipal, those primaries would be in August. And so just a couple of little changes. Representative Nyman tracked in every one of the changes we requested on third reading. But after seeing the engrossed version, Mr. Chairman, just 2 changes, and they're minor.
Go ahead.
The first would be page 10, line 4. And we request to strike beginning at the aforementioned through line 5, general election. What that would do, so currently when we publish our proclamation in August, or for the August primary, at the same time, we publish the proclamation for the November general election. And as written, we would be publishing that proclamation for November for the May and the August primary. Our thought process is we would proclaim for the May primary, August primary, and then the November general, 3 separate proclamations specific to their elections. The second amendment.
Could we just, I want to make sure that we got it. We're not going to vote on it right now, but so the new language on line 3 would be, each proclamation shall also include the date, there's two these, so you'd probably want to get rid of one of the dates. Include the date that a runoff election would occur if necessary?
That's correct, Mr. Chairman.
Okay, we got that. Keep going.
The second would be page 14, line 10, and this is very, very minor. On line 10, strike A and replace with each. I think it's clear right now, but just to make it expressly clear that there are two certifications from the Secretary of State's office, one before the May primary, one before the August. It's a very simple change, and again, I think it's clear, but just to make it expressly clear that there's two separate certification dates.
Okay, so just, I'm going to read that back to you. Page 10, the single word A is gone, and we're inserting each, correct?
That's correct, Mr. Chairman, on page 14.
Got it. Line 10, page 14. Then gross copy. All right, back to you, sir.
Mr. Chairman, really, that's all I have except for questions. The only piece I'd add, section 3, do expect us to have some conversation about a redistricting year and the process of us drawing district and precinct lines. To follow up on a Senator Landon question, one reason having the legislative races in May was problematic was the district and precinct line drawing becomes more complicated, as you well know, in a redistricting year. The statewide and federal, we just need to have some clarity. So expect us to bring that up at some point, but I think that we can accomplish it. And then section 4, we do believe as written, this would be a continuous appropriation or need to be continuously appropriated. The genesis of section 4 was if a runoff was required, the county would be made whole on that. But now it's every May primary, which there would be one every 2 years, would be reimbursed. And that was our request, just as we're adding more work and like Mary said, especially the smaller offices will likely need to add some staff, whether permanent or temporary, just because it's in the heart of budget season. But Mr. Chairman, those aren't things that we can't overcome. And so as written, we can administer this bill. We would just ask for those two simple amendments.
Okay, Senator Boner.
Thank you, Mr. Chairman. My question revolves around that first one you mentioned on page 9 and 10, looking at section 109, talk about when you issue the proclamation. And now with your suggested amendment, it looks like we're going to continue to do a proclamation for both primaries. I'm just wondering, is there any reference to the proclamation for the general election if we strike that language that you suggested?
Mr. Irvin?
Mr. Chairman, excellent question. Subsection B of 22-109 addresses the general election proclamation. It's not in this bill, but in the election code, subsection B outlines the general proclamation.
Thank you very much. Anybody else? Can we go back to the appropriation? So the thinking is that there's a $2 million account that's created to be used for reimbursement. And then this seems to suggest that we draw on that 2 million, and then it's up to the Secretary of State to ask in his budget or periodically to top that back up. And that's not exactly the same as continuously appropriated, right? So I looked at Senator Steinmetz, who has experience with the Appropriations Committee.
Mr. Chairman.
Yeah, and Senator, I'm just wondering do we want to have a $2 million account that's always there that they can draw on and it's available? Or is it, how do you read that?
Well, Mr. Chairman, I think it shall not revert or continuously appropriated are basically the same thing. I mean, it's on 39, line 1, shall not revert.
So Senator Steinmetz, my question is, I can get shall not revert. That means it stays in that account and it's used. Continuously appropriated means that it's topped off, that it's another $2 million. So, well, not exactly. I'm trying to understand whether it's topped off automatically or it just doesn't revert to use.
Mr. Chairman, I think this says it shall not revert, and then the Secretary of State comes back and asks for more if he needs it.
Okay.
May request appropriations, because continuously appropriated really is the same thing. We're not reverting that. I mean, it's not in this bill, but we see it in other bills. I think
Right.
it's just another way of saying it.
And then, Mr. Irvin, I'm back to you on this. Does that fit with your understanding? Because I thought you were asking for something different.
Mr. Chairman, as written, I think that's exactly what it says. It would have to be a request of the secretary through the budgeting process. We're just making our pitch now, and on the record.
See, I thought so.
Because it's such a policy shift, we're adding a third election, that May primary would continue to be paid for by the state. I think Section 4 is fine. We don't have heartburn with it. We just want your committee to know that expect us to have our hand out, asking for help for that May primary in a financial sense.
Right, and so if you had a preference, it would be that there's always $2 million in the account. It gets drawn down, but it's replenished. Would that be accurate? I'm getting
Mr. Chairman.
your lobbyist down here.
Yeah, Mr. Chairman, we would always, of course, appreciate that security, but however, the committee and the legislature sees fit for Section 4. But one thing, Mr. Chair, and I know this isn't necessarily popular, but we're adding more duty, more requirement to an office that has a number of roles. Vehicle titles, land transactions, marriage licenses, and as Mary mentioned, the county budget. And so it's just another piece we're adding, and to have that appropriation really helps us to offset those costs, especially while we're in budget mode. And so some security in Section 4 would be nice, but as drafted, it's also fine.
Yeah, and understand it's going to go to appropriations. They're going to have a lot to say about that. Yeah. Anything else, Mr. Irwin?
No, Mr. Chairman, just appreciate the opportunity to do this remotely.
Anything from the committee? Back to anything for Ms. Langford? Thank you, Ms. Langford. All right, let's fill out the chairs with people who wish to address this bill. Thank you. Ms. Simmons, go ahead.
Good morning, Chairman. Again, Gail Simmons, Civics 307 and Y vote. And I have a handout for you that actually has a table with the election times, including the proposed first and second primary. And there should be enough for folks that I hadn't put in there.
It's coming around now.
Okay. So, Mr. Chairman, I think this bill takes the prize for the least subtle of all the elections bills, which is pretty amazing given that there were 45. The state majority party apparatus doesn't like Governor Mark Gordon and are still upset with the results of the 2018 primary election. How unfortunate for them that he continues to enjoy one of the highest approval ratings in the country. It certainly does not justify an upheaval of this level in our election processes. Perhaps the catch title of the bill could be changed to the 2018 Primary Results Protest Act. First of all, the bill requires a majority rather than a plurality. This is the exact opposite of the testimony by some of the same people for the prohibition of ranked choice voting, which forces a majority. Note that while I do not believe RCV is appropriate for Wyoming, it certainly achieves the stated objective of this bill without creating a third election in the cycle and the additional cost and burden on the clerks. The runoffs only apply to any federal offices or top 5 state electeds. All remaining offices are still in the August primary. If, and this is a question, if the federal offices include president, that would be the only positive I see in this bill. Registered Republicans could actually vote for their preferred candidate, which they currently cannot. It's done in a meeting of the party. The Democrats use caucus for presidential primaries, so they have the opportunity to vote for that. So the question is, why not the legislature? Or just move the entire primary election up and have August be the runoff? This change in particular impacts those high school students who reach the age of majority between May and mid-August. Wyoming Republican primary elections have historical participation rates from 60 to 70%, while the Democratic is even lower. The general elections are typically 90 to 95%. Pulling this in early is likely to make those rates even lower. Historically, I looked all the way back to 2002, to 2000. In 2002, both the governor and SPI for the Republicans would have. Reps would be Democrats in 2004, Republicans in 2008, both Republicans and Democrats in 2010, the Democrat senator in 12, Democratic senator in 14, U.S. rep in 16, nobody in 2018. Actually, governor in 2018, sorry about that. In 2020, it was 0. Interestingly enough, in 2022, if this was in place, we would have had a runoff for the current Secretary of State and the current Superintendent of Public Instruction. So the other thing is on the other states, there are 11 states with some kind of runoff. All but 2 of them are in the primary only. And in all of those cases, it is a single primary, and the runoff occurs somewhere between 2 weeks and 9 weeks after that joint primary. Not one single one has a pre-primary, which is being proposed in this. If the issue is truly about reflecting the will of the majority, that can be accomplished by changing our closed primary elections to top 2 open primaries or jungle primaries. The party could nominate via caucus, both parties, which gives complete control to the party. This also eliminates the concerns about change in party affiliation in almost all races at each level of government, from county up. The result would be competition between 2 Republicans in the November general election. This bill is entirely being written based on the fact that we currently have a supermajority in one party. That has not always been the case, and I would propose that that is not a valid basis for doing policy, because we happen to have a supermajority now, and I stand for questions.
Okay, questions for Ms. Simmons? Questions for Ms. Simmons? Could you explain, I'm not sure I got the point of calling it a pre-primary and other states do a runoff within the primary. Can you say what you meant by that? I'm not sure I got it.
So all the other states have a single primary where everything is on the ballot. Every office at every level is on the ballot.
Okay, and then
So
the runoff that they have.
And then the runoff they have is run anywhere from 2 to 9 weeks following that single primary, if there is a runoff.
Okay, and so the races in the runoff obviously would be the ones that are, it wouldn't be all the races
No,
again.
it would just be the criteria, which runs from 35%, almost all but 2 of them are at 50% plus 1.
Okay, and so just let me see if I can reach this. So we're the opposite, because we would have everybody on the ballot in August, but we'd have this pre-primary for particular races. That's what you're saying?
Yes, Mr. Chairman.
Okay, thank you. Anybody else?
And I would like to know about the president, if that's included in the federal. It hasn't been addressed.
Senator Boner says no, but we'll figure that out.
Thank you.
Thank you. Ms. Russell, welcome.
Thank you, Mr. Chairman. Kathy Russell, Wyoming Republican Party Executive Director. We stand in support of this bill. This bill has been worked, as has been pointed out, for a number of years. One of the assumptions is in having to deal with it this way is that the state of Wyoming has assumed to oversee and select candidate nominations, do candidate nominations through a primary ballot. So with the assumption of that authority comes certain responsibilities, and that is to be responsive to the political parties in what they want to do. Ms. Simmons correctly identified that the Democrat Party does their pre-selection of candidates through a caucus system. The Republican Party has not, and that is a nationwide issue that cannot be decided at the state level. So this bill addresses many of the issues that have come forward over the years of dealing with this issue. Again, this is one of the top 3 issues for the Republican Party here in Wyoming to deal with election security and integrity, the objective of which is to correctly reflect the will of the Republican Party. I can say that internally, when we have elections, we do runoff elections to assure that the majority is electing their people. The assumption that in the way we do it right now, the assumption is that no one would change their vote if people were, if it was handled in the way of a runoff election. For example, the assumption is that that same ratio of favorability would exist if you opened it up for just 2 candidates. So we believe that this bill addresses the issues that have been brought up in previous discussions, and that this would answer many of the concerns that people have about the majority, and this being a candidate nomination process. Thank you, Mr. Chairman.
Thank you, Ms. Russell. Questions for Ms. Russell? Any questions? Thank you. Ms. Kaufman, right? Did I have that name right?
That is correct, Mr. Chairman Case.
Go ahead.
Thank you. My name is Jill Kaufman, and I'm from Platte County. And in my going through multiple cities this last year, expressing and sharing information on the vulnerabilities of the machines, I agree with Kathy Russell that one of the most important things is this runoff. So the people are really for this runoff bill. I'm not going to reiterate the extra stuff, but I just want to say the people are saying, yes, we are for this bill. Thank you.
Thank
I
you.
stand for
Questions for Ms. Kaufman? Questions? Thank you, Ms. Kaufman. Ms. Carpio.
Thank you, Mr. Chairman, members of the committee. My name is Marissa Carpio. I work for the Equality State Policy Center. We've been focusing on fair elections and transparent government in Wyoming for over 30 years. We do appreciate the intent of this bill and having a majority of our electorate prefer one candidate, but we do have serious concerns about the added costs, longer campaign periods, and lower voter participation that might come out of this bill. About 1 in 4 eligible voters participated in the 2024 primary, and expecting voters to show up for 2 different elections, one in May and one in August, just to narrow the field of candidates to get to the general election, I believe presents a significant challenge for most voters. Along with the campaign season now starting in February, we will see more money spent by candidates. I think Ms. Simmons already mentioned that the Secretary of State and the Superintendent of Public Instruction would both be included in those folks that would need a runoff election as the results were laid forth in 2022 in the 2022 primary. And the Secretary of State candidates spent just over $250,000 per candidate. And so that would increase with another election if we needed one. So we are electing with this bill to spend more money on a runoff election that is still closed to those not registered to a certain party. ESBC believes that other primary reforms, like ranked choice voting, would be a more effective way to ensure candidates receive majority support from voters and could be completed in a single election. Thank you, and I'll stand for any questions.
Thank you very much. Any questions for Ms. Carpio? Senator Dockstader.
Ms. Carpio, what's your assumption? You said there'll be added cost, but you said you anticipate less turnout. What are you making that assumption on?
Ms. Carpio.
Thank you, Mr. Chairman, Senator Dockstader. What we've heard from voters is that the primary election in itself and the campaign season this past in 2024 overwhelmed voters. And so adding another date, another few months of campaigning, I think would deter more voters, in my opinion.
I think we had some testimony about the turnout in the primary versus the general. It was something like 27% in the primary and quite a bit more in the general. We did have that testimony. Was it you or was it Ms. Simmons maybe? Oh, she raised her hand back there over your head. She was more direct in her, anyway, to you, Ms. Carpio, for any comment.
Mr. Chairman, thank you. Yes, that is right, that the turnout for the primary was much lower than in the general. I think Ms. Simmons gave the turnout for registered voters, and I'm using the numbers of turnout for eligible voters, so 27, and I believe it was maybe 56 to 59% in the general.
Thank you very much. Anybody else? Thank you, Ms. Herman. Welcome.
Thank you, Mr. Chairman, Committee. This is Marguerite Herman. I'm here for the League of Women Voters. And just a note, I think it was 27% of eligible as turnout, and I think it was somewhere less than 10% of registered voters for the primary. So it showed a very uphill battle to get people to turn out. I'll just mention there is one part of this bill. The League doesn't really have a position on the bill itself. We very much like the provision that increases from 1 hour to 2 hour the work break for voting. I think that there was another bill this session that I don't know what happened to it, and that the other bill did include, I won't talk about the other bill, sorry. But anyway, the 2 hour break, I think, considering the lines that we saw in the 24 election, makes a lot of sense. You can't expect someone to go and come back and have a vote if there is a line at the polls. So we're very much in favor of that. And just philosophically, just to kind of have others have said, our concern with this is the time and the money, and you've heard about that enough to know what that means. Money not only for the candidates to raise, to mount a campaign, but also especially a statewide campaign, and the money that would come in to influence the election. Elections are numbers, and the person with the most number wins, and that's how it's usually gone. And even if that is a plurality, that's how. And so this really is a major change that says it's not just the most votes, it has to reach a threshold. And whether that is worth the dislocation of the system as we know now, I guess that's up to you. That's a decision, but it is a consideration. And I guess also just to mention, since ranked choice voting has been brought up, the League has a position on open primaries. And if indeed the one party fact of Wyoming, which everyone acknowledges, creates an overwhelming, where the primary is the election, which is de facto the case, that maybe an open primary where the top two people advance to the general it would be a solution, wouldn't change the dates, but would maybe cure the problem that is being witnessed here. Let me see, I'm sorry. And this is motivated, this bill is motivated by an issue within one of our the Republican Party. And so it's asking a lot to change, and we haven't even got into mailing absentee ballots overseas and that sort of thing that created, adds to the burden to the county election systems. And so I would say that, so this is like that, I'm sorry, my notes are a little jumbled at this point. Also, the other thing that has been mentioned repeatedly is that, in fact, our current governor, although initially made it through a primary with, there were a lot of candidates and had didn't have a majority, didn't have the 50 plus. Had a plurality, and now enjoys wide popularity in the state. And I would say, just as a kind of a comfort to a party where the candidates do get elected with a plurality or make it to the general, then they get the majority, is that candidates in Wyoming, when they get elected, they take that seriously. They serve the whole state, and they proceed to govern well, and they proceed to govern with the confidence and support of the state. And so having made it through that first gate with the plurality, I don't think necessarily means that they do not go on to govern with wide support from the state, as happened as far back as I can remember, which is a long ways. But I would just say, once again, we don't take a position on the bill, but just to consider the understanding of the nature of the problem, other ways to perhaps address it, and the cost, the time, And people talk about, in a February filing period, but actually people before they file. So it's really 12-month. It'd be November to November would be really the election season this would create, which is time, it's money, it's a distraction for people in the legislature who, as you all know, your days are quite full by just being good legislators. So it's, the cost is high, and just consider if it is worth correcting a system that may not be completely broken. Thank you.
Thank you, Ms. Herman. Senator Steinmetz.
Thank you, Mr. Chairman, and I was gonna let this go, but I've heard it twice now. And it's concerning to me that folks are coming up and impugning people's motives on this bill. I think that they just want fairness across the board, and it has nothing to do with this current governor because it won't affect him at all. And so I mean, if our current Secretary of State and our Superintendent of Public Instruction would have needed to have a runoff, then they should have. And I think most people in the state that I talk to are in favor of that. And so I just want to kind of tamp down the rhetoric a little bit from a couple of our speakers, because this is not directed at any one person. It's a policy consideration before the body to implement something that several citizens have approached me about. And it's not directed at any office holder now, or just because it will only apply going forward. We can't go back and change history. So I just really would appreciate it if folks wouldn't apply motive to a bill.
Thank you, Ms.
And I apologize.
Hold on, please, hold on.
Sorry.
Thank you, Senator Steinmetz. Ms. Herman.
Oh, I'm sorry. And I apologize if it sounded like I was being accusative or criticizing. It's just the most recent example that came to mind is that a statewide elected official was elected with a plurality. And as just using as an example that, as I mentioned, people who are elected to those statewide high offices then do go on to gain support. They govern well. They understand the problems of the state, the desire of the citizens of the state, and they do go on to gain support because they take that office seriously and they do govern well. So I'm sorry if I sounded critical. It was just using that as an example.
Thank you, Ms. Herman. Any other questions for Ms. Herman? Thank you. Who else in the room would like to address this? Mr. Moline, welcome.
Mr. Chairman, Brett
Go ahead.
Moline, excuse me, Brett Moline, Wyoming Farm Bureau Federation, sitting in support of this bill. This fits with my members' policy. We've had longstanding policy that we want runoff elections. That policy's been in our book since before I started, so at least 20 years. Of all the choices out there, this is the one that my members want. It's simple, it works. And I think it could quite well generate more interest in the elections. Our turnout, for whatever reasons, are low. I think that this could generate more interest in the election, not only by the people voting, but by the people running. Sitting in firm support of this bill, Mr. Chairman, I'd take any questions your committee may have for me.
Thank you, Mr. Moline. Any questions for Mr. Moline? Anybody? Thank you, Mr. Moline. Anybody else in the room wish to address this bill? Anybody else? Do we have people online? Nobody online? Committee, you've heard the testimony. What is your pleasure? I heard it from Boner first. Discussion of the bill. We didn't really go through the bill, you guys.
Mr. Chairman?
Senator Dockstader.
Mr. Chairman, do you want the amendments together from the clerks or individually?
However you propose to make them.
Mr. Chairman, page 10, clerk's first amendment, line 4, delete, starting with because we don't want to does, delete all the way through general election. And then if you want me to, I'll just add the second one.
Yeah, so that says each proclamation shall also include the date that a runoff election would occur if necessary, and then it continues in a sentence.
Mr. Chairman, correct.
Okay, and go ahead. Might as well pile on. I think we can do it.
Second Amendment to page 14, line 10. Insert each after before.
And get rid of the A.
Correct.
Yeah, everybody got that? Okay, if we do them together, you can divide if you want. All those in favor signify by saying aye.
Aye.
Any opposed? That's carried. Back on the bill. So just the way the structure of the bill is, of course, section 1 being new language. And section 2 is all the conforming amendments, which involves, there's a lot of conforming amendments, of course, but has everybody read the new language? Everybody happy? Do we need to go through it? It's kind of the policy. We're good? Does anybody have anything else on the bill? Okay. I can't get anybody to want to work up here, so let's call the roll. That doesn't mean it's not good, believe me.
This is a roll call vote for House Bill 249 engrossed runoff elections. Senator Boner.
Aye.
Senator Dockstader.
Aye.
Senator Landon.
Aye.
Senator Steinmetz.
Aye.
Chairman Case.
Well, they've been very persuasive, but I'll still be a no.
You have 4 ayes and 1 no.
Thank you very much. And thank you, Representative Nyman, Mr. Speaker. Good job. Appreciate it. Thanks a lot. Okay. The next bill for our consideration is House Bill 206, Elections Acceptable Identification, Revisions 2. We've got Representative Weber here. Representative Weber, welcome. I'm getting a cup of coffee. Do you want one? Okay. Just give me 1 second.
I'm jittery already.
All right. Thank you very much for your patience. I apologize for that. Please go ahead.
Thank you, Mr. Chairman and Senators. I'm happy to be here and good morning. This is probably going to be one of the quickest, easiest bills you look at today. I bring to you House Bill 206 and ask for your favorable consideration. This is a common sense approach to identifying a person to vote in Wyoming elections. Identification depends on recognition. If you want to identify a person, it is normal and common and usual to use a photograph. We recognize and identify people by their face. Medicaid and Medicare cards have no photo, only a name, a health plan number, and a coverage date. If I wanted to fly anywhere, TSA requires a real ID with a photo or a passport, and it does not accept Medicaid, Medicare cards. I also have to show a photo ID to pick up a prescription, cash a check, check out a library book, purchase tobacco, and even drive my car. Voting should not be any different. A photo ID is required for things we do every day. I asked some of the county clerks how many Medicare cards have been used. There wasn't an answer. I even talked to one of my co-sponsors is from the Wind River Reservation, and he had stated that there wasn't any. I don't know why we have this on as a acceptable form for an identification. But let's go through the bill, all couple pages of it. Page 1, the first few lines say a photograph is required as and accepted ID and repeals Medicaid, Medicare insurance cards as acceptable proof of ID. Under Wyoming's current voter law, bottom of page 2, or page 1 going on to page 2, we have the definitions. Part A specifies, the acceptable IDs. B, we're adding the following language, provided the ID includes a photograph of the person. Section 2 repeals the use of Medicare, Medicaid cards and acceptable IDs and provides for an effective date of July 1, 2025. What this bill basically says is that we're looking for an image, a photograph, to identify the person in front of us. The intent of voter ID laws, which require proof of identity to vote, is really to prevent voter impersonation and fraud. I stand for any questions and urge an aye vote to pass this bill unamended. And I stand for any questions.
Okay. Committee, any questions? I'm looking up the repealers. I have no doubt that that's what they are. Do you have them?
Thanks.
Okay. So 22-1102. It's a lot of Romanettes. Okay, I'm down to B5. B5 is a valid Medicare insurance card. This subdivision is repealed effective December 31st, 2029. Interesting on the repealer there. And Romanet 19, which is a valid Medicaid insurance card. It's a repeat. The language repeats. That's interesting. Did you see that?
Well, Medicare and other Medicaid.
Oh, maybe you're right. I got to get better bifocals. Yeah, it is. One is, the first one is Medicare,
One's the federal,
Romanet
one's
8,
us.
and the other one's Medicaid. You're right. And they're both repealed on 2029. It's interesting that even if we didn't pass this bill, it automatically would repeal. Go ahead. You represent.
Mr. Chairman, thank you. Yes, that is interesting, and the reason for the bill is that I don't think it's needed. The clerks don't have any information or statistics that say they have used this for anybody, and I don't think it's needed. We need to protect our identification in order to vote, and by doing that, we need a photo ID.
Fair enough. Any other questions? Thank you, Representative. Let's see what people have to say
Thank you.
about this one. Secretary Gray, welcome.
Well, thank you. I'm Chuck Gray, the Wyoming Secretary of State, and sit in support, I guess, of House Bill 206. This is a really wonderful bill. Voter ID is near and dear to my heart, was the lead on House Bill 75 in 2021. To get a bill through and get it on the books at the end, there were some things that came in on the floor that were weakening amendments that at the time, for us to get it started, maybe were things that we accepted, and we made sure to put a sunset on the Medicare and Medicaid cards. That was one of the requirements we placed on that in our conversations with AARP. But my intent was always that the legislature, that this body would come back in the future and go around the edges and really get true voter ID. And if there's a lot of graphs out there after the general election. I don't know how many of you are on Twitter, but a lot of them were on X, where they had states with true voter ID and states with sort of non-strict or non-true voter ID, and then states with none. And we were in the box of states that did not have a true voter ID law, a strict voter ID law, because of this issue largely, which is that we have some exceptions where IDs without photos on them are allowed. And when you think about voter ID, and again, we're not talking about registration here, we're talking about voter ID, which is when you go to the polls confirming that you are who you say you are, when you say your name and you're on the list presumably, and yes, we have same-day registration here, but you have to still check that box once you register same day in Wyoming. You have to do voter ID. When you don't have a photo, it kind of does away with the whole purpose, because you can't see whether somebody's impersonating somebody if you don't have a photo on the ID. And so that's why when IDs without photos are allowed, it really is viewed as a huge weakening part of the act. And I agree that this weakened the act considerably. Now, even though there's a sunset, and yes, if that stays, then I guess on January 1st, 2030, as we're celebrating that new year, we'll be able to say we finally have strict voter ID. But my hope is that we can get this resolved in the 25 session for the 26 election. So this bill essentially does two things. First, it repeals Medicare and Medicaid insurance cards as forms of acceptable proof of identification to vote under Wyoming's current voter ID law. That's the repealers. And then second, and I think this is a very important addition to the act, It specifies that the remaining forms of identification for voter ID, which include a Wyoming driver's license, a tribal ID card, a Wyoming ID card, a valid U.S. passport, a U.S. military card, a driver's license or identification card issued by any state or outlying possession of the U.S., photo ID issued by the University of Wyoming, a Wyoming Community College or Wyoming Public School, and a valid concealed carry permit issued by the state of Wyoming. It requires that they have a photograph of the person. So that's the second thing that it does, and it puts that into the code. This is good policy. Speaking of the Medicare and Medicaid card repeal, these are two forms of identification which do not contain a photo of the person. Again, it's a huge weakness. The intent of voter ID laws is really to prevent voter impersonation, and you can't do that if you don't have a photo. They're also very easily reproducible. I've seen my dad's. I mean, they're very easily reproducible. Broadly requiring the remaining forms of ID to include a photo is with the intent of the act, and according to the National Conference of State Legislatures, of all the states that require voter ID to vote, Wyoming is one of 3 that does not require photo ID to vote. NCL notes that while, quote, some might call Wyoming's law a strict photo ID state because most voters will show a photo ID before voting. However, until December 31st, 2029, Wyoming will accept Medicare and Medicaid ID cards as valid forms of ID for voting, neither of which contain a photo. There are lots of states with strict voter ID. I think we've really crossed the Rubicon where this is widely accepted. I mean, I'm sure you've seen the polling, over 90% on voter ID, maybe even higher than that. The one thing I'll note, because, we're going first, and I enjoy our conversations with ARP. I've been working with ARP on this bill for 7-8 years. At first they were opposed, then they came around, and this was part of the negotiation that happened in the 21 iteration. Always enjoy working with ARP. I enjoy Mr. Laycock. I know they're looking at an amendment to try to get a hardship exemption into this. I would really ask the committee to resist that. I don't think there's any evidence that it'll be, they've been saying, it might just be 100, 150 people. We don't know that. When you have a carve out like that, it really eats up the entire rule. And in my opinion, either we make the policy change in this bill or we don't. But creating a hardship exemption, in my opinion, is really eating at the heart of a voter ID law. If someone can just sign an attestation and get around it. Remember the plaque I have on my desk. Got to have you there, Chairman Case, in my office. I want to sit down and catch up with you a little bit. It says, election integrity is more than just an attestation. That's what I have on my desk. And I think if we're going to move towards a carve out on voter ID for an attestation to get around it, I just think it's not the intent of this bill. And to me, it's an up or down sort of policy choice. Appreciate our ARP thinking about this issue, but that's my opinion on that. So very in support of the bill.
Thank you very much, Mr. Secretary. Senator Landon.
Thank you, Mr. Chairman. So, Secretary, interesting, the only person to approach me on this issue was somebody who likes using their concealed carry permit to vote with. I respect that. They're very proud of it and they like using it. But it doesn't have a photo on it, does it?
Mr. Secretary.
It does have a photo. Okay.
Mr. Chairman, Senator Landon, thanks for that question. I wanted to make sure we button that up. It does have a photo, and we added concealed carry, of course, in the 24 session, or 23, excuse me. And it's a great addition. People are very passionate about that. I think it was a great addition to add that. I don't think this would be affected by this bill.
Yeah, thank you, Secretary. I think people, that's a prideful thing. They like using it.
Yes.
So, thank you.
Thank you very much. Anybody else for the Secretary? Thank you, Ms. Secretary.
Thank you.
Do the clerks want to discuss this? Do we need to bring in Mr. Irwin again? Okay, go ahead. Ms. Langford.
Mr. Chairman and Committee, I'm Mary Langford, and I'm here to represent the county clerks again.
It's okay.
My purpose today is to focus on the administration of Wyoming elections and voter ID. In Wyoming, Medicare and Medicaid insurance cards are the only in-person voter ID that is required to be produced immediately before voting that has no photo ID. They look like this, and they're flimsy. They are slated to be repealed on December 31st, 2029. This bill will expedite that repeal to July 1, 2025. So they're slated to sunset, to give time for these folks to be able to get proper IDs is what the intent was in the beginning of that. Our concerns, the clerks have done some recent research, that was in January, on current use of these cards, and it is difficult to know how many people will be affected. In reviewing the 2024 election season, it could be as small as several hundred qualified electors statewide. Unlike student IDs that we have discussed, these qualified electors may have no other forms of ID, and it may be difficult for them to get a government-issued photo ID. However, even if it is just one qualified elector who is denied the right to vote, that is not acceptable. In other states, accommodations have been determined to assist those without photo ID by means of declarations or an array of other documents providing proof of identity. This could be a workable solution for the Wyoming voters. County Clerks Association would be supportive of other documents that would allow these qualified electors to vote, because again, every voter should be able to vote. So the people that we're concerned about, particularly with this, are veterans, seniors, and folks that also have had their documents destroyed in a short order. For instance, if you had a fire yesterday and the election's tomorrow, some of those kinds of situations. Those folks all still need to be accommodated as well. But we are concerned about those few folks that may not be able to secure a photo ID and still be able to allow the time that this particular law is set to be able to sunset, to allow them to be able to get a government-issued photo ID by 29, as it was originally intended. And with that, I have nothing else. I'd be happy for questions.
Senator Lambert.
Thank you, Ms. Langford. Have we ever had a situation through any of the clerks where we've had someone show up without ID and having a pretty good reason for not having ID? In other words, the house burned down, we lost all our documents. You make a very good point. I don't know that that would ever take place, but you know, I don't intend to try to fence anybody out either.
So, Mr. Chairman.
Ms. Langford, you gotta go through the chair.
Mr. Chairman, Senator Landon, our Fremont County Clerk tells a story from the recent election that happened. I believe it was a mayor candidate in one of her small communities that typically did have this happen. He'd had a fire, all of his documents were destroyed, and it was within days of the election. He had no photo ID and had no way to get a photo ID to be able to do that. I personally have an experience during my time in office. I had a lady that had lived in part of the county, and amazing, she had no ID, and she didn't have a social security card, which is amazing in these days and times that you don't. She had been a ranch wife. She had poor eyesight. She didn't have a driver's license. She wasn't able to see. She appeared at a polling place because she had lost her registration, her voter registration, because used to be back in the day, you signed up on a yellow card and you signed your name and they notarized your signature and you told them where you lived and everything was good. And anyway, you didn't have to produce anything. And she had been purged because her husband, who would drive to bring her to vote, had died. She had not, wasn't able to get to the election the last time, got purged. She showed up at the election the next time with her family, and she was provided a provisional ballot because she had no ID and she couldn't register at that point because the laws had changed. She came to me and to prove up on the next day, which you have 24 hours to prove up on your provisional ballot. And she had a card from a service organization that we are all know well in, a veteran service organization. She had an ID card from that. And she looked at me and she said, "You know me." I said, "Yes, I do know you. I've known you forever, as long as I've lived in the county." And she said, I have nothing else, and I've never had anything else. You know, and how do you go to the canvas board and say, this lady proved up to me, her vote should be allowed to count today, I believe, because she did the best she could with the time she had. So that's a war story, but it is a situation where she's a qualified elector. She had been a qualified elector. She got purged. She couldn't prove up, you know, with the documents that were required then as compared to what the documents had been maybe 30 years before. So that's the story that I have, sir. Yeah.
Thank you. Anybody else?
Mr. Chairman.
Oh, yeah, go ahead, Senator Dockstader.
So, Mr. Chairman, under existing law, this sunsets in 29. This would expedite it to 25. If we held it to 29 and the clerks would favor other forms of photo ID, is that enough time to put something together legislatively to address the photo concerns?
Ms. Langford?
Mr. Chairman, Senator Dockstader, I think it would be able to. I believe that there's someone coming behind me that may have some suggestions for you for something that could be, you know, could work for these few folks that are going to fall through the cracks if we don't figure out some way to accommodate them.
Anybody else? Ms. Langford, recalling how we used to do elections in your county and my county on the other side of the mountains, I mean, I certainly can recall going to a particular table to pick up your ballot and having the election judges there and they knowing your name and they checking you off the list and not showing anything. And, you know, now everybody would have to produce a photo, even though in these small towns in Wyoming, in the circumstance you mentioned that woman, there was no doubt of the woman's identity. There was absolutely no doubt. But the law got in the way of possibly preventing her from voting when there was no doubt. So I know we have to do things to be careful, but you know, when you go to that table where the precinct people are, they're your neighbors. They know you, and they know everybody. They're pretty much busybodies. Love them dearly. But so it does seem like we're losing something in my mind. But anyway, let's hear from someone else. Mr. Laycock, you were mentioned prominently. Welcome, sir.
Thank you, Mr. Chairman, and no, I'm not one of the people in the room considering a run for governor. Good morning, Mr. Chairman. Tom Laycock, AARP Wyoming. We're a membership organization for those age 50 and over in the state of Wyoming. When I spoke with you earlier this week, I mentioned it felt like my members, specifically those in nursing homes as well as those who are homebound, seem to be taking the brunt of the impact from these election laws. And here we are again. So with that said, I'd like you to think of my comments sort of through that lens today. We just got done hearing a lot of comments, a lot of bombast, a lot of cliche, probably better suited for social media and campaign mailers, about why there's a need for a change in our law. What you didn't hear were any metrics that really illustrated a substantive change is needed in Wyoming. It was suggested this morning that a number of other states require photo ID only to vote. We heard that also in House corporations. That testimony was actually debunked by a member of the public who happened to be waiting to testify and just did a quick Google search. It was also suggested that a number of states, or I'm sorry, it was also suggested that clerks don't know of anyone that's actually using these Medicare cards for voting. In fact, that's also incorrect. We've heard numbers in upwards of 300 people. We haven't figured out a good way to keep those folks from being swept off the rolls. Finally, it was also mentioned during last committee's meeting that we learned illegal aliens may be using Medicaid cards picked up in California to impact our elections in Wyoming. It takes me back to that old saying, never let the truth get in the way of a good story. In the name of not falling down that same rabbit hole, let me offer a few facts. During that same House Corps meeting, the Secretary of State told the Corps Committee, since 2021's voter ID bill was put into place, our elections have gone off without a hitch. We agree. So does the state of Wyoming. In fact, during a 2024 survey by the University of Wyoming Survey Research Center, 92%, and I'll say that again, 92% of the 524 people that they called expressed satisfaction with the voter ID rules as they currently stand. Last month it was, we agreed. Let me go back just a second. It was also suggested you needed a photo ID to board a plane, rent a motel, buy a gun, and do a lot of the pieces of everyday life that are really easier with the photo ID. We agree. In fact, if you look at AARP Wyoming's front page of our website, you'll see a story we put together with Misty Zimmerman and pinned at the top that explains to people why an ID is important, how to get one through the state, no matter what stage of life you're in. If you go to the NCSL website, you're going to find a comprehensive list of every state's voter ID requirements. That same website lists a hardship clause for every state for those who can't find their way to getting a photo ID. Some states are very laxed. They allow for a credit card. They allow for a piece of mail. We think that's probably a little bit loose. Other states, for example, the state of Nebraska allows for a nursing home registration, which is the same thing that we just amended into House Bill 156 for voter registration. Even the state of Idaho allows you to sign an attestation you're a registered voter in a specific precinct under penalty of felony for liars. While we do not believe a change in the law is needed, others do, and I thought I'd bring a compromise today using the same method as used in the state of Texas. In Texas, those who cannot obtain a photo ID can fill out what's called a reasonable impediment declaration, which includes the last four of the Social Security number, the impediment itself, and back that up with a number of documents such as birth certificate, proof of residency, or medical billing statement showing the residence of a precinct. The voter is then allowed to cast the provisional ballot if their identification is able to be verified by the county elections board. In our proposal, that decision to accept the ballot would rest with the county clerk or county canvassing board. County decisions could be appealed to the state canvassing board. Once the clerk is able to determine the legitimacy of the impediment listed in the declaration, match the address shown on supporting forms of ID and the last four digits of Social Security number with the voter registration data available. We believe this hardship provision is a great compromise and empowers our clerks to separate those who struggle to get ID with those who simply don't want to. In workshopping this concept with several stakeholders here today, we haven't gotten any good reasons why this wouldn't work, as it does already in the Lone Star State. In closing, I've sat in on a number of hearings where the need for election integrity tends to have a line that goes something like this: if even one illegal voter votes in a Wyoming election, it's one too many. And we agree with that wholeheartedly. We also feel if even one person loses their ability to vote who's been casting votes for the last 50 years, we think that's one too many, and we assume you do as well. So that said, I'd be happy to stand for any questions.
Okay, questions for Mr. Laycock. Senator Landon.
Mr. Laycock, thank you. I didn't have time to look up other states, but you mentioned that it seemed to be pretty prevalent that there were hardship clauses in this part of their statutes. Is that accurate? What did you see when you did some homework?
Go ahead, Mr. Laycock.
Mr. Chairman, Senator Landon, NCSL has a dynamite website for this. They've got everyone's requirements. They've also got everyone's hardships. And I think what they've found is, if you're around me any too long, you're going to get tired of hearing me say governing is nuance. It may not be something that's easily done at a coffee shop. It's something that other states have looked into, and there's a reason that they have these backstops. Hardships really span the gamut, like I said. Some of them, for example, in the state of Iowa, you can bring two people to the same precinct who are able to show ID, and they're able to vouch for you, basically sign for you, say, yes, this is mom, something along those lines. So they really span the gamut, but what you find is everyone's got something, and there's a reason for that.
Anybody else? Senator Steinmetz.
Thank you, Mr. Chairman, and thank you for bringing this, because when my grandma was still with us, she had to get a real ID driver's license, and she was born in a shack in Nebraska, so she didn't have a birth certificate. And a lot of her documents that she did have were in German because they were from the German church she attended, and we had a heck of a time getting her a real ID compliant driver's license. So I get there's really a problem. I don't see any actual language from you. I see some information. If we did move this on, could you provide us with some language or help us find what you think? Because I do think having a few people that could vouch for you in the community, I mean, would be something that would be helpful, especially in her case. It was a lot of work to get her a driver's license, so I understand what you're saying. Could you provide us some language is the question if we move this forward today?
Mr. Laycock.
Chairman Case, Senator Steinmetz, that's a really cool story. And as someone who grew up in a area that spoke exclusively German in Iowa until about World War I, it's very relatable. The answer is yes, we actually do have Texas's language that they've used. The beautiful thing is we can use that as a model. We can move into rulemaking and put some more restrictive things into the reasonable impediment application if that's the will of the body. It's something we can use, but we do think it would probably fit somewhere in 22-3-118. So we've kind of done the work on that front to figure out where that might live too. But yeah, that's easily found.
Can you be more specific?
Mr. Chairman, is that the handout that you provided?
Mr. Chairman.
Mr. Laycock.
To the talented Ms. Sharp, that language is not actually on that handout, but I'd be happy to get that for you very quickly this morning.
You might need to do that. Senator Boner, did you have?
So, Mr. Chairman, just on your handout, you have a list of, different forms of identification, birth certificate, utility bill, mortgage statement, that sort of thing. Is it, and this is from Texas, it's my understanding, do you just require one of those things, or do they just require one of those things down the Lone Star State, or is it multiple?
Mr. Laycock.
Mr. Chairman, I believe they require two pieces to make it valid. Once again, that's the beauty in setting up our own system, that we can, if we feel like two, that's great. If one's okay, then we can do that too.
Okay, anything else? Senator Dockstader.
Thank you, Mr. Chairman. Mr. Laycock, I have concerns we're targeting a group of people and denying them a right to vote until we get this sorted out, to move it through this fast. Between now and 2029, do you think you could work with all parties and stakeholders to get something organized to address that photo issue?
Mr. Laycock.
Mr. Chairman, Senator Dockstader, I would love to. In fact, it's a little late now, but this would be a great interim topic, but we can do this outside of the interim as well. As the Secretary mentioned, I don't know, what, 7, 8 different meals that we got together on for the first voter ID bill. I'm sure we could come together with something. But once again, that backstop seems to be pretty universal, and there's a reason. That said, we'd be happy to pick this up over the interim and bring back some options. The nice thing is we're in a place right now where there's not many elections between now and next session. And if we go through the interim, we come up with nothing that's acceptable, I'll sit down and shut up. But I think we probably owe it to ourselves to at least give this a look.
Thank you, Senator Dockstader. Anybody else? All right, thank you, Mr. Laycock.
Thank you.
And if you can find some language, we'd appreciate it. Who's else? Let's fill out the chairs. Yes, please come. Ms. Herman, welcome.
Thank you, Mr. Chairman, Committee. Marguerite Herman here again, League of Women Voters. And I guess I really like the alternative that was offered by Mr. Laycock. But as just referring to this bill, I just wonder what's the rush? When the voter ID was put in place, it was considered that 2029 gave people who did use it for a voter ID, not registration, but voter ID, that gave enough time for people to get something to replace it. And I think that's still valid. I don't know what the rush is to move that up. Certainly nothing would be harmed by keeping it in place. I did check with my county clerk, the most populous county. There has never been a case of a Medicare being used that was fraudulent for voter ID. So they're not being misused by all evidence. And this, I don't see the rush to move it up. I think what I hear from the clerks is that use of it is getting lower and lower and lower. It's not zero. And so, in lieu of a complete repeal, you could move it up to maybe 2027, but I just don't see the reason to phase it out prematurely, since when the bill was passed, 2029 seemed like a reasonable window to allow people to do that. And I guess independent of that, the league would certainly like inclusion in state law of the alternate route to versus to make a hardship case, the impediment that Mr. Laycock talked about. That would be also good. That's not in this bill, so just the date of being phased out is our concern. It doesn't seem to be a reason to speed it up to that level.
Questions for Ms. Harmon? Any questions? Thank you, Ms. Harmon. Representative, welcome. Representative Lucas.
Thank you, Mr. Chairman. Good morning, committee. It's a pleasure to be here. I am Ann Lucas, and I'm the representative for Wyoming House District 43, although I am not speaking in that capacity at this moment. I'm speaking as a citizen and a former banker. I spent over 40 years working in banks and credit unions, and a good number of them here in Wyoming. The federal government has a law that's commonly called the Know Your Customer Law, and they are required when opening an account and performing certain transactions to obtain a list of identification cards or sources, and none of them are Medicaid or Medicare cards. I can tell you that in over 40 years of serving in retail banking, not corporate banking, but with real people, I can't recall a time when somebody wanted to use a Medicare or Medicaid card as identification. It just doesn't happen very often, is my guess. My mother passed away a few years ago, but was in nursing homes for a substantial amount of time and was required to show photo identification in addition to her Medicare card, because we know that we hear cases of Medicare fraud. And interestingly, although I know it'll be hard for you to believe, I received just in December a Medicare card of my very own. I know it's hard to believe, but I went to the doctor and I had to show them that card for the first time. And it's a doctor my husband used to work for. They know me well. And they said, could you please give us your driver's license? Also, we're required to have photo ID with a Medicare card. So I'm just really emphasizing that Medicare cards are routinely not used as identification in many facets of our society. And I suspect that the instances where people cannot get a state ID or a driver's license are rare. I think, we just don't see these anymore. We hear the stories, but how long ago did that happen? I think right now it's probably pretty customary that folks have photo ID. That was my statement. I'd stand for any questions.
Thank you, Representative. Senator Landon.
So, good morning, Representative. Good to see you. As a private citizen and not a representative, do you believe there should be any hardship rule in this area of law?
Representative Lucas.
Thank you, Mr. Chairman. Senator, I can't think of a situation where that could happen, but I live in the big city in Wyoming where it is very customary. I don't know anybody who doesn't have an ID that is an adult, and that doesn't mean I know everybody, of course, but I can't think of that situation where that would be necessary, perhaps if a house burned down. But then I suspect that folks have other things that they're dealing with at that time. So no, sir, I can't think of that. I don't understand why we would need that.
Thank you. Anybody else? Thank you, Representative.
Thank you.
Ms. Kaufman, welcome.
Thank you, Chairman Case. My name is Jill Kaufman. I'm still from Platte County. And this is absolutely an important aspect of our voting integrity in our state. I come here as a citizen and as an election judge who signs an oath to have all the voting done properly. I've seen so many people come through my table who they throw a Medicare card out in fun and they say, you don't know who the I am, do you? And then they give us their driver's license. So the people are frustrated with being able to use the Medicare because they know that it's not a good form of ID. The other thing that is interesting is they do throw out the concealed carry as well. They usually throw out both, so we get to use the option of both. But a voter ID is absolutely a necessary part of an election integrity. And it'd just be a great thing to prevent any type of fraud or any type of shenanigans in our state. I stand for questions. Thank you.
Questions for Ms. Kaufman? Thank you, Ms. Kaufman. Ms. Russell, welcome.
Thank you, Kathy Russell, Wyoming Republican Party. The party stands in favor of this bill. This is definitely one of the holes that has to be filled, is to assure verifiability and accuracy. There's been a real trend over the last few decades to go toward convenience and laxity to make sure no voter misses an opportunity to vote. But I think I can safely say from people I have talked to that the mood has changed, and people want to make sure that their vote is not negated by someone who is not qualified to vote. This would fill that hole. There are plenty of national and international news reports, investigative reports, and memos from agencies and commissions about the proliferation of false IDs. And I've used this example before, but I know of a case in Colorado, in Arizona, where a staffer of the governor had their voter ID stolen and someone else voted in their stead. So when they came to vote, somebody else had already voted with a false ID. So this is an issue, and this definitely would fill that gap. The other day I went to pick up a prescription, was required to give a photo ID. I followed that up with the deposit at the bank because it included cash. I had to present a photo ID. There are very few occasions where you would be pressed for time to get a photo ID before registering to vote. So we would stand in favor of this, and I personally would stand in favor of this to assure that my vote is not negated by someone who is voting illegitimately. Thank you.
Thank you, Ms. Russell. Questions for Ms. Russell? Questions? Ms. Russell, the incidents in Colorado where someone in the government went to vote and found out that someone had voted in their name, has a similar situation ever happened in Wyoming that you are aware of?
Mr. Chairman, it was in Arizona.
Oh, I'm sorry.
And I wouldn't know that, but I think it can be assured that we are not perfect here in Wyoming. There's always room for improvement, and this is one of the areas that needs improvement. Thank you, Mr. Chairman.
I agree with you. 1 second, Senator. If it did happen though in Wyoming, I think we'd hear about it. I think we would know. Someone would say, I went to vote and someone had already voted with my name. I think we would know about that in Wyoming. I think the clerks would know about that, and no one can say that that's happened. So that's kind of important in this whole thing. Certainly let you comment. Go ahead.
Mr. Chairman, I think the issue is to assure that it won't happen, regardless of whether it's happened in the past.
Okay, thank you, ma'am. Senator Dockster, sorry.
Mr. Chairman, I actually had the same follow-up question, so she's addressed it. Thank you.
Yeah, thank you very much. All right, let's see. I think Ms. Carpio was she who's at the table first? I don't remember. Whoever would like to go first. Ms. Richardson.
Thank you. My name is Micah Richardson. I'm with the Wyoming Women's Foundation. Our mission is economic self-sufficiency for women and opportunities for girls. We are looking at this bill similarly to how we looked at House Bill 156 and looking at our older population, specifically those older women. One thing that we would suggest if this bill were to move forward is to add that attestation piece into this bill currently that was added in HB 156. I can just say ditto to Mr. Laycock's testimony, I think. But if that were something that was of interest to someone, page 2, line 13, if a photo ID is not available, an attestation or an attestation in combination, we would prefer attestation, but in attestation in combination with one acceptable document listed on the Secretary of State's website would be, is basically very similarly to how you addressed 156. And we, again, prefer one because so many of our older women may not have the more than one of those listed documents. That is all. Needs to have for questions.
Want to give it to us one more time?
Sure. Page 2, line 13. If a photo ID is not available, an attestation is acceptable. If that is not something that is to this committee's liking, an attestation in combination with one acceptable document listed on the Secretary of State's website, which again, perhaps listing out what those documents are would be beneficial as well.
Okay. Members of the committee, any questions for Ms. Richardson? Thank you, Ms. Richardson. We appreciate it. Ms. Carpio, welcome.
Thank you, Mr. Chairman, members of the committee. My name is Marissa Carpio. I'm with the Equality State Policy Center. I don't want to spend a lot of time echoing other people's thoughts, so I'll just say that I agree with Ms. Herman's, Ms. Richardson's, and Mr. Laycock's testimony today. And the only thing that I'll add is nationwide voter impersonation, which is the fraud that voter ID stands to prevent, is almost non-existent. Studies show that it happens in 0.0003% to 0.0025%. And in all of my research and talking with, in records requesting the Secretary of State, I have not seen one instance in Wyoming of voter impersonation. So thank you. I'll stand for any questions.
Thank you for that. Anybody else? Thank you, Ms. Carpio. Do we have anybody online? Ms. Secretary wants another bite of the apple too? Yeah, go ahead.
There are a couple things, Mr. Chairman, thank you for this indulgence. I don't like doing it a lot, that I neglected to mention, and wanted to respond to. One, there are states that do not have a hardship exemption. I went on the NCSWL website, just pulled 5: Georgia, North Carolina, Arkansas, Indiana, Mississippi. And so the idea that every state has a hardship exemption, does not comport with reality, in my opinion. The other thing I wanted to note, and this happened on House Bill 75 in 2021, it was an amendment from Speaker Summers that came after Medicare and Medicaid was added to the list. And I think it is really the answer to the hardship exemption, which is that somebody, if they do not have ID, can get a Wyoming ID card for free for purposes of voting. And I was just at the DMV the other day. They have the form out. It says for voting, this is free. You just have to check a box. And that was a Summers amendment that came on after this was added on the floor that I really think answers the need for the hardship exemption, and I think is Wyoming's approach to doing that. And so if you don't have an ID, say something happens, a tragedy, a house burning down, something like that, you fill out a provisional and you have 48 hours to get to cure that, quote unquote. And the clerks have allowed the paper ID that you get as the temporary ID when you go to the DMV, whether it's an ID card for a driver's license or the Wyoming ID card. So all you'd have to do is go get that Wyoming ID card, and you'd have 48 hours to do that and cure that provisional ballot. So I think we have a Wyoming-based approach that came on with that Speaker Summers amendment that later as the process progressed. And that's not being touched with this bill. It really addresses the hardship proposal. And I think that really eats up the purpose of voter ID when you allow someone to get around it just by filling out an attestation. I just think it does. So I'm really for this bill as it's written. Thank you.
Thank you. Any questions for the Secretary? Senator Landon.
So, Mr. Secretary, thank you. I'm just compelled a little bit on this hardship front.
Mm-hmm.
I don't want to box anybody out, and we have a lot of folks out across Wyoming that live out in long ways, rural out, whatever. A lot of people in our resident nursing facilities and assisted living. So all of that said, I wonder what Idaho does with an attestation. Is that cleared through the Secretary of State, for example? That kind of intrigues me, and I wonder why that wouldn't be as good as contacting the Department of Transportation and trying to get something. I wonder, any thoughts on that?
Ms. Secretary.
Well, thank you, Mr. Chairman and Senator Landon, for that question. I believe Idaho has it in the code. I'm not 100% sure on that. I'm on the website and just clicked on Idaho. It says if ID is not presented, the voter signs an affidavit with name and address, period. some states have that, some states don't. To me, an attestation, allowing people to get around the requirement with an attestation basically eats at the heart of the bill. And the problem is attestations, they're all over the statute. And as Chairman Case has noted, one of the emphasis of our administration is moving away from them, because people, it's just swearing to something. And it's very difficult to prove if someone is falsely swearing. I mean, that's the problem with a lot of the questions on, do we have proof of this or do we have proof of that? When someone's swearing to something, it's very difficult to get proof that someone is lying on an attestation. And when you do, it usually doesn't rise to the level of a prosecution. But it's very important. It's very difficult to even get to that point when you have an attestation. So basically, the attestation swallows up the whole requirement. And if someone signs that paper, it's all forgotten, and they've met the requirement and affirmed that they've met the provisions in the code that allow them to. And if the code says that, then that's the process. But I would pose to you that is not the direction, I think, in terms of security that I would be supportive of. I think we need to just continue to have a strong code with the provisional process in place and the ability for people to get this Wyoming ID for free. They can certainly do that within 48 hours. Now, in terms of a nursing home, there's numerous options. One is they mail in the ballot. Under current law, somebody can turn in their ballot for them. With 238, I think, as amended with your amendment, they would still be able to turn in their ballot for them as long as they're a caregiver or someone being employed by them for the purposes of caregiving, and they could mail it in. I mean, that's sort of the absentee balloting a situation. But we're talking about voter ID at the polls on the day of the election, because we don't have absentee voter ID. There was a bill to do that I'm supportive of, but that didn't make it to the House, or it didn't get introduced. And so we're talking about voter ID is just in person, either for in-person absentee balloting, which was a change in the 23 session, or for in-person voting on the day of the election, which is the original bill in 21. And I just think we're there, and the attestation really eats it up. There was one other thing I was going to say, but I'm forgetting now. So I think I answered a lot of it. Thank you.
And Ms. Secretary, if you think about it,
yeah,
we'll certainly give you a chance. Anybody else? I do have a couple of questions, perhaps. The temporary, when you go and get a vote ID from the DMV, the department, and they give you a piece of paper, does that piece of paper, it's a temporary thing before your real one comes, does it have a photo on it? I've experienced that.
Thank you, Mr. Chairman, for that question. And that was what I forgot to say, is the process. You asked about the process for attaining that ID at first.
Yeah.
The temporary does have a photo, in my experience, unless there's across counties different experience. I've done this twice now because I've lost it a couple times. And so I've had it in the last years. It did have a photo on it. And the thing about the ID process at the DMV is you have to clear all those boxes, which includes proof of residency, which includes proof of citizenship in Wyoming. Now, other states are a little bit weaker on that respect. It is really an extensive process. So using that driver's license or the Wyoming ID, which is the same process as the driver's license, is the gold standard. And we've heard testimony again and again from the clerks, and one of the things we're going to be doing in WyoReg with e-poll books, at least when they're used, is we're going to track which ID people are using. It's from the testimony I've heard, it's 90% plus is one of those two, is the driver's license or the Wyoming ID. And so that's, it's the vast majority.
Thank you, sir. Thank you very much.
Mr. Chairman.
Oh, Senator Dockster has a question.
Thank you. Before you leave, Mr. Secretary, this is all coming to a conclusion anyway in 2029. In the meantime, I'm concerned that we're going to deny some good, honest Wyoming residents the right to vote and get this sorted out. Do you have any concerns about that, sir?
Ms. Secretary.
Thank you, Mr. Chairman. There's always a tension in policymaking between the security and the, whatever the word is, ease of access, or and there's always a tension. It's one of the tensions in public policy is usually that one, security versus fill in the blank. Maybe in this case it's ease of access, but I really think the election integrity over the last decade has come to the forefront, especially the last half decade. And I think that, you know, when this bill has been covered quite a bit by the media, and I think people really want us to have that strict voter ID requirement for purposes of election integrity and confidence. And I think that voter confidence increases turnout. And I think there are procedures in place if there is a case, and I'm not conceding there would be, for what would happen if someone is not able to meet the requirements of the bill, meaning they cast a provisional and they have 48 hours to correct with a free with a free Wyoming ID at their local DMV that would print out the paper one, the temporary one, and that they can use to cure that ballot. And I think that's really our version of the hardship exemption. And I know some might say, well, some might not be able to do that. But, you know, as Secretary Buchanan always said, voting, it takes a modicum of effort. He always used that phrase. And it's a balance. But I think we are achieving that balance with this bill in terms of my spectrum on it. And I understand everybody has a different one, but I think this is where the country's going. There's a wide feeling that voter ID has really crossed the Rubicon and that it should be the strict voter ID form.
Thank you, sir. Anybody else? Thank you very much.
Thank you.
I need a timeout for housekeeping, and since Chairman Knapp is here, I see that. I just need a timeout right now. I don't think we're going to get to the next bills until upon adjournment, so that lets you off. But there is a memo from Josh Anderson that relates to the bill we passed on 249, that it changes two dates that are in other Senate files. One of them is in your committee this afternoon, Mr. Chairman. And my computer, I just need to do this now, you guys. You're gonna have to.
No problem.
Sometimes you have to put up with me. It's like 249, and you have 166, I think. There's a conflict in the dates. You might go talk to Josh about that. And then I think the transportation has another bill. You have 190 and 166 is in transportation, but they have conflicts with the dates that came out of 249. So we have to take a look at that and see if that substantial makeup plan could just go to conference if that's what necessary to fix that, or we'll figure it out. And then could we start our interim meeting on Friday, say at 12:30 instead of, that would give time for people to grab lunch if that's possible. Okay, great. Back to you, Ms. Langford.
Mr. Chairman, Mary Langford representing the clerks. Just 2 points. To cure a provisional ballot, you only have 24 hours. That happens, but it has to happen by 5 p.m. on the day after the election. And in a lot of our communities also, to be able to get a ID card with through driver services through YDOT, a lot of communities don't have YDOT folks in their community every day of the week. They're only there maybe 3 days or 2 days or something like that. So it's not so easy. And yes, part of the reason why that identification card was provided for free is because we shouldn't have to pay to be able to prove our ID to vote. And with that, would stand for questions.
Thank you. Anybody? Thank you, that's a good point. Anybody else in the room? Anybody else online?
Mr. Chairman, we have Julie Tucker online, and she's just now unmuting her microphone.
Okay, we'll get Mr. Kaufman first. Mr. Kaufman, welcome.
There we go. Mark Kaufman, Platte County, business owner. I've been listening to the testimony today, and we have a ton of election problems. And it appears to me that all the testimony in here, I support this bill, but it sounds like we're ordering a screen door for a submarine here. The ability for people to sneak through the cracks, this is what this is supposed to plug up. but we are so concerned with everything else. Ms. Steinmetz and her folks, we are a resilient people in Wyoming. If we don't have the proper ID or the information to vote, we're gonna gosh darn sure get it. We just won't stand idle. So I think that's a focus that's misguiding this group. And if there needs to be other things to put into place for those particular people, that can be taken care of at a different time. But let's try to remove the screen door from the submarine first, and then address these other issues after that. I'm in support. I appreciate it.
Thank you very much. Any questions for Mr. Kaufman? Thank you. Thank you, Mr. Kaufman. We'll go online.
Ms. Tucker, are you there?
I am.
Okay, go ahead, Ms. Tucker. Welcome.
Thank you. Good morning, Chairman Case and committee members. My name is Julie Tucker, and I'm representing myself. First, I have to say it sickens me to hear that some of the panelists negate people with disabilities. I didn't hear anybody really mention disabilities so much. As a person with a disability, I am very concerned that people who are disabled or elderly may not be able to get somewhere to acquire an ID because they're bedridden or have no capability to get to a place where they can obtain a picture and ID. My question here is, has anyone thought of how the state can accomplish the task of getting these people an ID? Excuse me. Since they can't use their Medicaid and Medicare card, you heard from Mr. Laycock, around 300 people have used their Medicaid and Medicare card to vote so far. The people we're talking about here are disabled or elderly and some of our most vulnerable citizens. You're trying to disenfranchise their right to vote. For those people who are disabled, the Americans with Disabilities Act under Title II says reasonable accommodations should be made so they are equitable to those without disabilities. During discourse in at least 2 other bills, a representative and the Secretary of State made sure that people in the nursing homes were given favor. We need some help for the same people and others who can't get to a driver's license office to get a photo ID. Is there some kind of portable machine that could be taken around to make IDs on the spot, or could attestations be taken by a person who is the caregiver, like a doctor, a parent, or a nursing home supervisor? If there are not other provisions provided, people will be foregoing their constitutional right to vote in Wyoming. After all, this is the equality state where everyone should be able to vote. Thank you very much, and I stand for questions.
Thank you, ma'am, and I'm so sorry. I didn't write your name down. Would you give it to me again?
Julie Tucker.
Yes. Tucker. Thank you, Ms. Tucker. I really appreciate it. Let's see if we got any questions. Any questions for Ms. Tucker? Any questions? Thank you, Ms. Tucker. No questions. Appreciate it.
Thank you.
Anybody else online?
No, Mr. Chairman.
Okay. Committee, you've heard testimony. What is your pleasure? Motion by Boner. Discussion? Senator Dockstader.
Mr. Chairman, not on the bill, just in the concept in general. We are moving up to a time when we can address it at 2029. I'm greatly concerned that we're denying a group of people that may not have the ability to make this transition quickly enough. We're denying them the right to vote. So I'll be a no on the bill.
And Senator Dockstader, if there was an alternative attestation or something, would that change you? Slight maybe? All right. Other discussion? Senator Boner.
Well, Mr. Chairman, in light of that, I think it's important maybe we consider the handout we got from AARP. It allows for some alternative ability to prove up on who you are. And so I wanted, Mr. Chairman, if it's okay to kind of make a conceptual amendment based off of that information and give LSO the leeway to craft it as we see fit, or as they see fit.
Well, it'd be okay if you got 3 votes, so.
Okay, all right. So I'm thinking, just basically based off that first paragraph in the handout, and I'll just read it. Voters who do not possess an acceptable form of ID and cannot obtain one of the forms of acceptable ID listed due to a reasonable impediment may present a supporting form of ID and execute a reasonable impediment declaration, noting the voter's reasonable impediment to obtaining an acceptable form of ID. Acceptable forms of ID include any one of the following: valid voter registration certificate, certified birth certificate, copy of original current utility bill, copy of mortgage statement, copy of rental agreement, copy of original bank statement, medical billing statement, or explanation of benefits containing address.
Okay.
And so that's the conceptual amendment. I'm assuming that would be on,
You have to be an alternative B, I guess. Yeah.
But leave staff the discretion as to where exactly to put that in statute. But I think that concept is fairly, hopefully that's clear, Mr. Chairman.
It is. Senator Landon.
Mr. Chairman, thank you. I think that came out of Texas. If I'm seeing some head shake, yes.
So
just wanted to remind the committee that's where it came from.
Well, we don't like them Texans.
They're
So,
pretty conservative down there, though.
I'm positively inclined towards going in this direction. I would also be positively inclined that if you had some supporting testimony from, say, 2 electors that testified to your identity, it happened, pick up the case of Ms. Langford with the rural ranch wife. Could we add that in there somehow? That someone will, that there's already an elector, so we know who they are, that they would vouch for you. And I don't have language, you guys. And offering is friendly, but if it's not friendly, we can handle it separately.
Maybe it's best to handle it separately.
No
Mr.
problem at
Chairman.
all. Okay, back to the original concept discussion. All those in favor signify by saying aye. Aye. Okay. Is there any room that anybody would like to go down the direction of having someone swear to your identity? Does that happen in court, Ms. Sharp? I mean, is that ever, I don't know. It seems pretty archaic with the world today, but.
Not that I know of.
Okay.
Because you would swear to your own identity.
Right. All right.
Chairman, I like your concept, but I don't know that we have anything.
Maybe we can
Sets
work
up
on that if
statute.
you and I could do a floor amendment. Possibly. Okay, I won't go down to, anything else on the bill? All right. So,
Could we review that amendment?
yep. Go ahead, one more time, Senator Boner.
So I am going off of AARP's handout. So perhaps that would help some of members of the committee and members of the public who happen to have it. So basically 2 ideas. If they don't have an acceptable ID and can't obtain one due to a reasonable impediment, they can present a supporting form of ID, also execute a reasonable impediment declaration that states their reasonable impediment. The acceptable forms of ID are as follows.
And you've got a list. I don't think we have to go through it.
Okay, all right.
We okay? Okay, I'll call for the question on that. All those in favor say aye. Aye. Okay. Anybody opposed? Okay, if we did it, we just did it again, so it's in there twice.
Yeah, reconsideration, we did it again.
There's one piece here, you guys. One way this bill could go is that, I don't know that we have to repeal those sections, but because they go out on their own. The bill still has some use, even if those sections were to remain, but I leave that up to you.
Mr. Chairman.
Senator Steinmetz was reaching. Can I get her first?
Yeah.
Go ahead, Senator Steinmetz.
Thank you, Mr. Chairman. I think the amendment we just passed provides a reasonable approach and that we should go ahead and repeal that section.
Okay, Senator Landon?
I'm so inclined.
Same. Okay, anything else on the bill? Can we call the roll on the bill?
This is a roll call vote on House Bill 206, Elections Acceptable Identification Revisions 2. Senator Boner.
Aye.
Senator Dockstetter.
Aye.
Senator Landon.
Aye.
Senator Steinmetz.
Aye.
Chairman Case.
Aye.
5 ayes.
All right,
Amended.
we'll come back. Hey, you guys, we only got 3 bills left tonight.
All right.
So we'll start with House Bill 228.
Are the election bills?
Yeah, we're still
Mr.
on
Chairman,
elections.
Do you want to discuss whether or not you want a hearing on Chris Petrie?
Yeah, let's have a hearing on Mr. Petrie, invite him. Could we do it at 8:30 on Friday morning?
Sure.
I have a school facilities meeting.
It's no problem. We'd even let, you know, Mr.